Yes, my lord, I am mentioning one preventive detention. My lord, this is a situation where the ordinary criminal law is suspended. It is only under Article 21 that can come to your lordship and challenge the order of detention. My lord, I am being kept in custody in connection with PIT in DPS, not NDPS, it's prevention of illegal trial. And my lord, I have noted down all the grounds of urgency. This was being heard by Justice Rao. Rao had in fact directed them to refer any affidavit if they wish, the central government. But ultimately, now the have been shifted on 22nd of June. Nearly 1 year is being completed for the detention. My lord, nothing, my lord, of this matter.
Nothing will happen in 1 week, sir.
My lord, there will be 2 weeks, my lord, again.
Nothing will happen in 1 week.
My lord, I cannot, the difficulty is I cannot go to any court, I cannot pray for bail, I cannot do anything else.
Regular bench.
My lord, that is again in June.
2 weeks.
Okay.
Go on.
My lord, may I mention one appellate side matter, my lord? My lord, I'm seeking your lordship leave to move this matter, my lord, urgently. Because, my lord, at 2 p.m., because two similar matter already, my lord, running your lordship list and fixed at 2 p.m., my lord. And here, my lord, I submitted all my requisite document before the tender committee. Tender committee reject my lord, technical bit on the ground that I'm not submitted. And my lord, they... Yes, ma'am. It's appearing from their website that I submitted all my requisite document. They acknowledge it.
What is this matter, madam?
My lord.
Which tender you're talking about?
My lord, here ESI, my lord, floated a tender for civil work.
Yes.
My lord, here two matter already running if you my lord list, my lord, item number 3 and 4, my lord. This is similar matter, my lord, where I submitted my all requisite document, but the tender committee, my lord, they reject my technical bid on the ground that I did not submit my document. And my lord, they open one my lord financial bid for one, my lord, successful bidder in a technical bid. That can't be, because this is 1.8 crore, my lord, above limit, my lord. So, my lord, kindly, this is very urgent. If your lordship take this matter at 2 p.m. with item number 2 and 3, my lord.
In those matters, the financial bid has not been opened.
My lord, that is why, my lord, this is more urgent, my lord.
Not today, tomorrow.
We will give notice to them.
My lord, I will give notice to.
You have not even given notice to the other side.
My lord, I want to move ex parte, my lord.
No.
We give it, my lord, to...
So, Lord, we will serve notice on the party who is appearing for yes in those matters, but we'll serve notice on them.
Yes,
serve them notice, then mention matters.
We'll serve notice on them.
No ex parte. These are not matters. Tenders matters are not ex parte.
But I will
give them notice, but those who are appearing in item 2 and 3, we'll give them notice. The advocates who are appearing, we'll serve them notice.
before 2.
May I mention one matter when I'm praying for leave to file my requisition to drop and complete. The order dated 8 May. They expired on 14th May, man.
We have mentioned it from the original site matter, for extension of interim matter, This is going to be expired on 28th May.
Whose board? Justice Rao's board?
Yes, madam.
Expiring on?
28th May.
Same
Complete.
The matter of the Mr. Honorable Justice Rao, extension of interim of 20th May. Upon note.
My lord, may I have my lord's leave to mention, my lord, item number 216 of my lord's monthly list. My junior had mentioned it, lordship had asked to come in the end of this month, my lord. This is a section 34 application, won't take much time. My lord,
Before always take
no, my lord, it won't, because I know, my lord, this is beyond the agreement. It won't take much of it. I've secured the amount. It's a small time trader, my lord. I'm not even troubling, my lord. If lordship fixes any date after reopening or in July.
We'll see after reopening.
My lord, lordship only said to come in the end of May to get it fixed, my lord. My lord, then, my lord, I know my lord's diary. It's full for June. Full for June, my lord, practically. We've all got our matters fixed in June. Yes. That is why I'm saying even in July, I'll be happy, my lord.
We'll see that after the
So may I come back and mention after?
after the.
Great,
M-
great.
My lord, may I have your lordship leave to mention a matter? Your lordship might recall that is the ATS tank trust matter. Your lordship have taken this ATS tank trust matter. Your lordship have taken this matter from the determination of my lord Justice Krishna Rao, my lord. I'm mentioning so for the purpose of the necessary correction. On the 14th May, my lord, the name of the respondent has been recorded as IOCL. Instead of the IOCL, my lord, the name of the respondent would be the HPCL, my lord. In Lord Shiva, WPA number 11099, the name of the respondent would be the HPCL and landed counsel would be recorded. May I just place the corrected order? On 13 May, your lordship has placed a
So there were two respondents. One was two matters for IOCL and one for HPCL.
HPCL.
The HPCL one you mentioned.
Yes. On 13 May, the name of the counsel has been correctly recorded, my lord. The Bishwanath Chatterjee is appearing on behalf of the respondent.
To be mentioned. Keep it to be.
My lord,
Make the correction in the order. Make the correction in the order and give it to be mentioned tomorrow.
My lord, may I be permitted to mention, my lord, one execution matter in commercial division for inclusion, my lord. By an order dated, my lord, September 2025, the respondent was directed to secure, my lord, rupees 60 crores. They have not done so, my lord, neither they have filed the affidavit of asset in terms of the order. Therefore, my lord, any day, my lord, this matter can be
Not
taken
right
up
now,
after.
after vacation.
And my lord, one inclusion for 29A, my lord, the mandate.
After vacation.
May I be permitted to mention item 117, your lordship's today's brief, you know, the urgency is that, my lord, an application, my lord, I am a subscriber, the award holder is the AP. After, my lord, the petition was filed by the petitioner, I went to an amalgamation, my lord. It's name change. My lord had on earlier occasion permitted me to withdraw the award amount subject to, my lord, furnishing the bank guarantee. The bank guarantee has expired on 8th of May. My name has changed, my lord. I am seeking, my lord, a substitution in the
File an application.
Look, that is an application in item 117 appearing in.
We'll see that. There's no
My lord,
urgency.
may I
Lord,
What is the urgency?
my time has expired. If you lordship do not extend, my lord, my the registry will, my lord, invoke the bank guarantee which is already there. I have gone through amalgamation by an order of NCLT. Therefore, my lord, Willman Cargo has changed to a different name.
Right.
That has to be substituted in the AP, and my lord, I should be permitted to, my lord, file, my lord, bank guarantee in the new name.
Who will invoke your bank guarantee? The registry will. Why will the registry invoke the bank
Because
guarantee?
it is given in the register, my lord, as a security because our debtor has furnished the security amount in a 36 application. I withdrew the amount pursuant to a lordship order subject to furnishing the bank guarantee.
Right.
That is, my lord, expiring on 8th of May. My lord, has expired. Unless, my lord, my name change is allowed, my lord, and I cannot file, my lord, the new bank guarantee in the name of.
My lord, may I?
There's no inclusion right now.
Lordship, may I be
Last.
permitted to mention for inclusion for withdrawal, Lordship?
Withdrawal gives.
My lord, may I permit to mention for restoration application?
Not right.
My lord, may I be permitted to mention the section 14 application for dismissal because the entire arbitration proceeding has been withdrawn and there is also attached withdrawal order.
Lordship, may I be permitted to mention on section 11 application for inclusion?
No inclusion right now. Wait.
May I be permitted to mention, Lordship, section 33 application was filed by the Arbitrator and that was disposed of directing the Arbitrator secure sum of rupees 2 crore 70 lakhs by way of bank guarantee to the original site register. Lordship, the bank guarantee has already been expired on 16th March 2026 and we have issued a new bank guarantee and for that reason, Lordship, we have filed one G application. I'm praying for inclusion.
My lord, I am for the award holder in this matter, my lord, which has been served.
We are allowing that.
My lord,
We'll allow that.
my
We
lord.
have taken that.
May I permitted to mention one matter, my lord. The matter, my lord, the petitioner has received, my lord, 6,000 for event booking, my lord. For that condition, my lord, my account business account has been closed, my lord. But without any reason, my lord, after inquiry, my lord, came to know that since I have received 6,000 rupees for event booking, my lord, for that purpose, my account has been blocked.
Who has blocked your account?
My lord,
Who has blocked your account?
my lord, the bank has.
On basis of which complaint? There's a criminal complaint filed.
Yes,
There's a
my lord.
FIR.
The complaint has been filed against the person who has transferred, my lord, 6,000 rupees in my account, my lord.
So there's a FIR.
My lord, FIR has been closed, my lord.
Lord, may I have the Lord, may I have the liberty to, my lord, mention a section 9 application, my lord. It's appearing as item number 35, my lord.
Not money taken, my lord, not repaid, and we have come to learn they had two shops. The last one is also on the verge of being closing down, my lord. We do not know, my lord, the whereabouts about the respondent, my lord. Any day, if your lordship permits,
We'll see.
this
We'll
matter
see.
can be,
Item 35, right?
my lord, of the, my lord, the monthly list.
We'll see. Right.
Sir, case number AP 635/2022 सर सेक्शन 34 6/4/2026 आप मेजनिंग हुआ, आप परमिटेड किया, लेकिन साहब अभी तक कोई रिक्विजिशन मिला नहीं, तो सब दोबारा हम लोग सबमिटेड किया मेजनिंग
Lawyer
स्लिप,
कौन है आपका?
तब हम लोग को होना था
आप
एनबीए तब। हाँ हम लोग
लॉयर कौन है?
लॉयर अभी नहीं है सर, वो टाइम मिलता नहीं है,
इन पर्सन
एक बार हुआ सर।
आप आफ्टर वेकेशन मेंशन करिएगा, छुट्टी के बाद
हाँ
Your Lordship, may I be pleased to mention a matter from the bench of Justice Krishna Rao. It is an original side matter. Your Lordship, it is against the port authorities paying for providing documents which are within their custody, Your Lordship. Goods went missing from the port
what
authority.
is the urgency?
The urgency is that on 18th of February, they had intimated reply to our notice stating they require some time to provide the documents.
What is the urgency this
Lordship,
week?
Your Lordship, we are contemplating the goods may be, criminal actions may be
Your Lordship, may I be allowed to mention a matter for inter-release? This is a two matters, pre-arbitration matters, of under Section 9 application for.
Wait, madam.
May I permit to
Wait,
mention a
wait.
matter? Your Lordship,
After vacation.
Your Lordship, the matter is listed in the list of main bench of Justice Krishna Rao. Actually, the matter is regarding the bank is withholding the money of the beneficiaries of the will, which has been duly probated in London. But till now, the matter has
What
not
is-
been listed up.
What is the urgency
They
today?
are all senior citizens and they are all in need of money.
Since
Your Lordship.
when is the matter pending? Since when?
Since 2025.
Wait. 1 week, nothing is going to happen. Go before the regular bench.
May I be permitted to mention a matter?
May I be permitted to take it over, Malad? I am leading.
Mr. Rai.
Malad, if it's possible, Malad, if your lordship allows me to.
Yes, Mr. Ray.
There's a bit of an urgency, Malad. This was filed earlier, Malad. The bank has been freezing my account on the basis of a complaint of another director. Now, Malad, this had gone to the ROC. ROC has found that there is no management dispute. Now, in spite of that, Malad, the bank is not debit freezing my account. What has happened, Malad? I was proceeding with my business. But now, Malad, at the end of April,
Mr. Ray, what is the urgency as of
yes,
today?
sir. I'm just coming to that, Malad. End of April, Malad, I have suffered a fire incident at my place, Malad. Now, this account has the major portion of the money which I need to recover my factory, Malad. And now the ROC has also said that there is no management dispute. In spite of that, Malad, the bank is not debit freezing it. So that, Malad, I can use this money, Malad. I am the company. I'm the company.
Bank has frozen the account based on
On a complaint which was filed by one of the directors for his removal. So this went to the ROC. ROC said there is no management dispute. In spite of that, Malad, the bank is not debit freezing the account. And I desperately need the money because the company has passed resolution that that person is not anymore there, and the directors have been put up and who are ready to take the money out, Malad. So it is the company who is making the application, Malad, because there's a fire which is broken out. I cannot manage without the money, Malad, now. I've been managing considering the urgency, Malad.
May your Lordship's kind leave.
Very grateful.
I'm mentioning, Lordship, to move section 47 matter, Lordship, with tender number. Lordship, because, my Lord, the department, Lordship, the master is not releasing the file saying that a section 47 has to be filed in connection with an existing execution proceeding. Lordship, there, Lordship, we have produced a Supreme Court judgment that section 47 can be filed even without execution proceeding. Lordship, apparently, Lordship, the master is of the opinion that our leave must be obtained from your Lordship.
Section 47 can be filed with the execution proceeding.
Lordship?
With the execution proceeding, it can be filed.
With the execution proceeding, it can be filed. Lordship, even without execution, in anticipation of an execution proceeding, Lordship, can be filed. Lordship will kindly ignore the underlines, my Lord. I'm sorry, my Lord. করেছি judgment Supreme Court. Here is the version.
She is right, sir.
Let's, section 47 can be filed. There are previous
You
judgments.
show me judgment. This is not enough. Show me
There is
judgment.
a Supreme Court judgment. There is a division.
That is what
There is a
the-
division bench of our High Court. I have appeared. Not we've done it
Show
before.
me, Mr. Chaudhary.
In this matter itself, it's happened.
Is
Show me
there
that
is a
47
previous
can be
section
filed
47
separately,
also.
not in execution proceedings. Separate petition can be attended under 47. Right.
I'll
not
mention
convinced.
tomorrow and show my.
May I have your lordship's kind leave to mention section 11 petition for inclusion, and if your lordship would be kind enough to fix a date after summer vacation. The urgency is that
Mention after summer vacation. What is the urgency?
Why are you looking back?
What is the urgency?
Urgency, section 11 filed here by Milord the other side. Section 11 filed by us before the Delhi High Court. Our cases, Milord, it should be in Delhi. Seat is Delhi. They say, Milord, forum selection clause here. So, Milord, the interesting issue is seat versus forum selection clause, which is perhaps undecided by Supreme Court till now.
in domestic.
In domestic arbitration, seat versus a specific forum selection clause. Everything else is decided.
Let Delhi High Court decide.
Delhi High Court says your lordship must decide and it doesn't proceed.
After vacation.
Heard substantially after vacation, Milord, whenever it pleases your lordship,
Mention after.
mention after vacation. Chalo.
Your Lordship, I'm the petitioner. The matter has been settled between the parties. This is my instructions.
Learned counsel for the petition seeks to withdraw the present petition since it has been amicably settled between parties. The instruction from a client to withdraw the present petition is taken on record. The present petition is dismissed as withdrawn. Interim orders, if any, stands vacated. There's no warrant of arrest in this, right? Is there any warrant of arrest, madam?
No, Your Lordship. Is there any warrant of arrest?
Well, may I please, your lordship? This matter, my junior mentioned, some sections and acts, perhaps not referred to what has been,
Yes, what is the section?
lordship, kindly have a look to this earlier order.
I just give me the section.
Section 102 and 103 would be there under,
10
cooperative society 2006.
2106.
My lord, kindly come to paragraph 14 of the current, of the present judgment, lordship.
Yes.
Paragraph 14, lordship.
Yes.
Here it is written, my lord, that he further submitted that petition number 1 being a cooperative society under the Cooperative Societies Act 1961. But, my lord, it is of, it is perhaps in my understanding, my lord, that it is non-existent. My lord, 2006 or my lord, 1973. So it is there.
Challenge that, sir. All right. If it is non-existent, you challenge.
My lord, kindly,
Tell me, is there any correction?
kindly,
Is there
my lord.
any correction? Don't tell me what is there, what is not there. If there's any correction, you tell me.
No, my lord, not exactly, my lord. Some these are to be required to be corrected because sections are there and acts are, my lord, also mentioned. My lord, can I mention, my lord, in paragraph 18 also the same thing has happened.
Yes.
Paragraph 19 also, paragraph 26 also, paragraph 27 also.
So what is the correction? Sir, don't Mr. Nayak.
My lord.
Can you make life easy? Can you please tell me the section which you are saying is incorrectly noted here?
My lord, that I will not say, but my lord, we have not referred. Lord, so kindly have a look to this earlier order also. Kindly have a look to this. Then. This second judgment, kindly see, my lord, what we are challenging. Kindly see to the first, that's the only one page. First page, lordship. First page, lordship.
You keep it tomorrow. I'll have a look at it.
Can I make one application, my lord, short application to that effect?
I will do it, sir, whatever it's, you challenge,
My lord,
I will see it.
My lord, I have some
Please, can you
corrections,
tell-
my lord.
Yes.
My lord, yeah, paragraph 16, 30 and 31, my lord, the judgment name is Vidya Dolia and it's referred as Vijay Dolia.
Vidya.
Vidya Dolia, VIDYA.
Page?
My lord, paragraph 16, 30 and 31. And my lord, paragraph 13, my lord, the learned counsel's name is, my lord, Shomo Ray. So it's written as Roy. Only these.
Which paragraph?
My lord, paragraph 13. R-A-Y, my lord, R-O-Y. It's written R-O-Y.
But for a moment, would your lordship kindly see, my lord, paragraph 26?
Yes.
Paragraph 26, lordship, can you see the third line? Not just two lines I'm placing. At the outset, the objections raised by respondent number 1 respect to maintainability on the ground of the petition is a cooperative society registered under Cooperative Society Act 61. It has not been stated by us anywhere. Be that as it may, is considered it is contained as the respondent number 1 that in view of the section 108, 109, these are not also been referred to us. We have referred to 102 and 103 of the 2006 Act. This is, these are not. I do not know what my learned friend will say. 61, they have stated in their petition. But it is, it is unfounded. We have argued, 2006 Act.
102 and 10?
103 of the Cooperative Society Act 2006. Because there is a dispute mechanism is there. Arbitration mechanism is also there. So I refer to that. But my lord has observed, to that extent, we have no objection. Very well, arbitration.
Let's see that.
And one prayer shall I be make?
File page. No,
Milord, can I make also one prayer, Milord? Because all the parties are coming from Balurghat, North Bengal, lordship. If this arrangement could be, Milord, direction could be a little bit changed there also. Any arbitrator therein, lot of arbitrations, Milord, persons are there. All persons will come here. Property is also there.
Once order has been passed, it has been passed. If there's a clerical error, I can make that correction. Otherwise, no correction. Just give it to me. I'll have a look at it.
Then, Milord, kindly make it day after, not tomorrow.
Day after.
Day after, Lord.
Day after. To be mentioned day after.
Shall I make one application? No.
No need.
Grateful, Lordship. Grateful.
Item number 16, Lordship, may I be allowed to appear virtually?
Yes.
Lordship, in this particular section 11 application,
you have to move an application.
Application for recalling of the order, Lordship.
Yes.
Very
Then we'll
well.
change it.
Very well.
Otherwise, this is not a critical error. It is a section.
Lordship, yes, the arbitrator who was appointed, she has recused herself from the appointment.
Yes.
So, Lordship,
Move an
I'll
appropriate application, we'll do it.
Lordship. Great.
No. You'll move an application, we'll let it be in the list only. No correction is.
Lordship, a formal order may be recorded. We will then file an application with that particular order giving the liberty.
Upon mentioning, learned counsel for the petitioner states the arbitrator who has been appointed has recused himself, herself.
Herself, Lordship.
Has recused herself, full stop. She prays for a change in the arbitrator. Let a proper application be filed. Learned counsel for the petitioner seeks and is granted liberty to file appropriate proceedings, appropriate application in accordance with law. If the order dated so and so is required.
Grateful, my lord. Seventeen, my lord, is my execution application for correction of the order, lordship.
Like
In the
a typographical error has crept into the judgment dated 13/5/2026 in para 8. It is recorded as follows. Para 8 पूरा quote कर ले. The same shall be substituted and read as learned counsel for the decree holder submits that he would adopt the arguments advanced by the Banerjee, learned counsel appearing in EC number 334 of 2020. The rest of the judgment and order dated 13/5/2026 shall remain unchanged.
Grateful, my lord. May I take your leave?
Yes. Same 17 to 30. नहीं इसमें इस ये मेंशन किस 17 में किया है ना इसने 17 to 31 सेम हो
Well, this is my fourth, na third. Second, my lord, 29 application, awaiting only for the award. She is not well, my lord. My lord's last order at page 66 records everything.
No difficulty, your lordship.
If your lordship sees the last order of my lord only at page 66, dated 10th of December 2025, it records everything, my lord. She's not well, my lord. That's the only difficulty. Rest is Banerjee, my lord.
The petitioner has preferred the present application under section 29A of the Arbitration Conciliation Act, seeking extension of the mandate of the arbitral tribunal for conclusion of the arbitral and publication. Learned counsel for the petitioner, Mr. Banerjee, submits that whole arbitrator was appointed by this court by order dated 17/5/2023 to adjudicate the dispute. Proceedings were completed on 12/10/2023. Consent of the party, the mandate of the arbitral tribunal was further extended till 21/3/2025. By order dated 3/3/2025. Court further extended the mandate of the tribunal for 8 months till 20/11/2025. As a later by order 3/3/2025 and 10th December 2025, the mandate of the arbitral tribunal was extended. पहले था 8 months and
पूरा दीदी तो बोलो सर्विस तो दो
4 months. respectively. Learned counsel for the respondent states that the respondent has no objection to the said extension of the arbitral tribunal's mandate. The counsel for the petitioner submits that the final arguments have been concluded on 21/9/2025. The matter is presently at the stage of publication. Learned counsel for the petitioner states that the learned arbitrator is undergoing health issues and thus has been unable to publish the award within the extended time period. Full stop. Being satisfied of the reasons given by the learned counsel for the petitioner, this court sees that there is no unwarranted or undue delay on part of the learned arbitrator, since her health condition is an impediment in passing the award within the publishing the award in the extended time period. Keeping in the same fact, this court extends the mandate of the arbitral tribunal further for a period of
Anytime, Lordship, leave it to my Lord.
how much time do you think she'll
2 months, ঠিক আছে? My lord,
for a period of 2
means
months?
she's recovered, but I'll pray for 3 months. I leave it to my Lord, my lord. Whatever Lordship pleases, my lord.
Further for a period of 3 months from today. Learned sole arbitrator is requested to publish the award within the extended time period. Full stop. Instead of observation, the present petition stands dismissed.
Grateful. My lord, Lordship is extended from today or
Today.
today? Great. তাহলে জানিয়ে দিই।
Affidavit sends.
Grateful. জানিয়ে দিই।
I agree with the response. Please, Your Lordship, this is the respondent's application under section 29A, my lord. There are, my lord, 23 contracts between the parties. These contracts relate to, my lord, maintenance of heavy earth moving equipment. So there are 23 claims, and, my lord, I have 19 counterclaims. 3 witnesses, my lords, have been presented by the parties in this reference. And the time expired on 14th of March, 14th of May. This application was preferred within time, my lord, before the mandate expired. The fact that there are, my lord, 23 references which are being heard simultaneously, in my respectful submission, my lord, constitutes sufficient cause to beseech us to beseech your lordships to extend the time, my lord. Now it is at the stage of final arguments. The claimant is
Application is filed by you.
yes, my lords. I am the respondent, my lord. Counter,
Application filed by
my lord. This is the fourth. This is the fourth extension, my lord. The last
I can see 14th
one
November.
Yes, please, my lord. 14 November, your lordship was pleased. This is the second time we are troubling your lordship. Now, my lord, it is at the stage of final arguments. The opening submissions on behalf of both parties have been completed. The claimant is in rebuttal of its claim, and I have to respond to my counterclaim, my lords. This is the stage at which it is presently. Hearings are in fact fixed for tomorrow and day after.
Take down. The petitioner has preferred the present petition under section 29A of the Arbitration Conciliation Act 1996, seeking extension of time period for conclusion of arbitral proceedings and publication of the arbitral award. Learned counsel for the petitioner submits that this court-wide order dated 30/7/2021 had appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 15/11/2022. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended till 13/5/2024. Full stop. Thereafter, this court-wide order dated 22/5/2024, 10/11/2024, and 14th November 2024 further extended the mandate of the arbitral tribunal for 6 months, 1 year, and 6 months, respectively, thereby extending the tenure of the tribunal till
My lord, 14th May 2026.
14th May 2026. Learned counsel for the petitioner further submits that the final arguments on behalf of the respondents.
My lord, I am the respondent in the arbitral reference, my lord.
Final argument has been completed.
My final arguments have been completed. They are in rebuttal, my lord. Your lordship sees the first
Final arguments by the petitioner is completed and the rebuttal of the same is being advanced by the learned counsel for the respondent.
I would have a right to rejoin, my lords, because I have a counterclaim.
Matters at the stage of final argument.
Please, my lords.
Don't write anything. Matters at the stage of final argument. Learned counsel for the respondent states that she has no objection to the present petition for extension of the mandate of the arbitral tribunal. This court has heard the submission advanced by parties for the both the parties and has carefully perused the materials placed on record. Upon consideration, this court is satisfied that there is no undue or unwarranted delay on part of the learned sole arbitrator for conducting the proceedings. Considering the advanced stage of the arbitral proceedings and in the interest of justice, this court deems it appropriate to grant a further extension of how much time?
Can you grant us 8 months, my lord? That will suffice, my lord. Because now we'll be 15 days, my lord. We'll lose for the summer vacation. Lordships, give us 6 months, my lords. In that, my lord, we made this progress. Kindly see this, my lord. We conclude. I don't want to trouble your lordship.
Enough. Finish it off. Going on for 4 years. 2020.
Because 23 references, my lord. That is why, my lord, and claims running into more than 300 crores, my lord.
8 months.
So then 23 awards will have to be made and published, my lords.
Extended for a period of 8 months.
I'm grateful, my lord.
From today, the arbitral tribunal is accordingly requested to make all endeavors to conclude the proceedings within the extended time period and publish the award.
My lord, just one indulgence. I'm just saying if it can be recorded, the allegations are deemed to be controverted, my lord.
Not into 29A, there's no allegation.
My lord, there is, which is why I'm making this prayer, my lord.
We are not asking for affidavits in 29A.
Grateful.
Grateful, my lord.
It please your lordship. Lordship, I'm for the petitioner. The affidavit of service is with the record. This is my section 29A application. This is a list of dates prepared.
Who's on the other side?
Lordship, I had served it, Miss.
Appearing in the.
Yes, they are appearing in the arbitration.
They're appearing, then you serve them again.
Lordship.
Email service.
Email and hand service. Email service. I'll hand serve it again.
All right, counsel for the petitioner seeks and is granted 2 weeks time to effect service upon the respondent after 3 weeks.
Grateful.
May it please your lordship, my application under section 29A, this is my lord the second extension application. At the stage of the arbitration is arguments have been concluded. Now only preparation of the award is pending. If necessary, the tribunal may fix a sitting for clarifications. That is the statement. The last order is at page 30, my lord.
She started the dictation one. She started dictation of the award.
Dictation, that is what I was also informed.
Who's the arbiter?
Well, I am the claimant in the arbitration. I am the petitioner.
No objection.
Well, Lordship has passed an order, madam. The statutory body has not taken. Short time may be given so that he can just only pass the award, madam. Nothing remains.
Voluminous documents, my lord, can be considered. 3 to 4 months will be.
The present application has been filed by the petitioner under section 29 of the Arbitration and Conciliation Act 1996. Extension of time for and publication. Learned counsel for the petitioner submits that the sole arbitrator was appointed by an order dated 19/12/2023 by this court. Full stop. Mandate of the arbitral tribunal was mutually extended by the parties 10/11/2025. For the party submits that the matter is at the stage of publication of award.
Publication of the.
Thereof, the petitioner is seeking extension of the timeline for the publication of the award by 3 months. Learned counsel for the respondent states that he has no objection to the said extension. Upon consideration, this court is satisfied that there has been no undue delay on part of the learned sole arbitrator in initiating the proceedings. Full stop. The matter is at the stage of publication of the award. Full stop. Considering the advanced stage of the proceeding and the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 3 months. From today, the learned sole arbitrator is requested to ensure that the award is published within the extended time period with the aforesaid observation. Present petition.
Deeply obliged. 3 months from today. For publication of the award.
This is my second 29A application. My lord, the first, my lord, by consent, my lord, it was extended on 20th of July 2024 under 29A3, my lord. That's, my lord, lordship will find that at page 31, my lord. And then, my lord, will find, my lord, on 8th of May 2026, my lord. Sorry, 1st of May 2025, my lord, lordship had extended, my lord, the mandate for an year, my lord, which is at page 41, my lord. My lord, which is expiring on 7th of May 2026. My learned friend is cross-examining the witness, my lord.
I have no objection, Lordship. May I extend? There's second witness.
Application for extension of the mandate of the arbitral of the learned arbitrator. Learned counsel for the petitioner states that this court, by order dated 26/4/2023, had appointed a sole arbitrator to adjudicate the dispute between the parties. Proceedings were completed on 28/2023. The consent of the parties was extended by 6 months till 28/6/2025. Full stop. Subsequently, the court further extended the mandate by 1 year. The matter is at the stage of recording of evidence.
Cross-examination of my witness, my lord.
Cross-examination of the you're the petitioners.
I am the claimant, my lord.
Witness. Full stop. Learned counsel for the respondent do not have any objection to the extension of the mandate of the arbitral tribunal under these circumstances, and considering the progress made in the proceedings and for the ends of justice, the mandate of the learned sole arbitrator is extended further for a period of how much time?
This is January.
8 months.
8 months.
8 months
of life.
From the date of from today, enables the learned arbitrator to conclude the
date of communication of the order है तो आज से क्या होगा?
the aforesaid direction.
January.
Present application stands.
Date to fix that you cross करो. Cancel.
I'm
grateful, but जानिए तो
Section 9 Act now 37.
If this is a partnership dispute, my lord, the application is under section 9. My lord, the immediate concern is, my lord, that was served on us, my lord, asking us to expel as to why we should not be expelled as partners, followed by, my lord, expulsion order. Now, my lord, so far as this is concerned, I had started telling your lordship on the last occasion the background of the matter. My lord, before I take your lordship the papers, I think it will be simpler to explain the situation. Now, my lord, this is a partnership, my lord, which carries on business of mining in the district of Orissa. Now, my lord, naturally, there are a lot of, my lord, compliances, statutory compliances that are required. And the mine is, my lord, essentially allotted to the mining contractor without any right of transfer. My lord, this will be an issue. That's why I'm mentioning this before your lordship. Now, my lord, so far as this firm is concerned, this partnership was last reconstituted in 2019. My lord, the partners were, my lord, the parties before your lordship. Now, my lord, one partner had in the meantime also died. My lord, that is Mufazzalur Rahman. My lord, kindly make a note that he died on the 16th of June 2023. Now, my lord, naturally, upon his death, the firm was required to be reconstituted. There's a provision in the partnership deed which says that, my lord, in the event a partner dies, his heirs will be invited to join the partnership. But, my lord, if they decline, then, my lord, of course, they may not join. Now, my lord, in this case, in 2024, his heirs have declined. They said, I will not join the partnership. Now, my lord, so far as the partnership is concerned, Section 5 of the Partnership Act says, my lord, partnership is a creature of, my lord, contract, not of status. So, my lord, the contract between the parties is, my lord, supreme. It governs the relationship between the partners. Now, insofar as the relationship is concerned, my lord, two partners were designated joint managing partners. One is, my lord, Mufazzalur Rahman, who is no longer there, and the other is, my lord, Siraj Usha, who is the respondent number 1. Incidentally, Siraj and the petitioners before lordship, that is Miraj and Sarosh, well, they are all uterine brothers from the same mother. Naturally, there has been a fallout, my lord, between the brothers. Now, my lord, importantly, coming back to the issue, my lord, the partnership deed provided that there will be 2 joint managing partners. All the other partners, apart from, my lord, the lady partner Hamida Khatun, will be working partners. And under the deed, they have an obligation to participate in the affairs of the company with full vigor and vitality. Now, so far as the joint managing partners is concerned, they don't have omnibus powers. They have, defined and restricted powers under the partnership deed. What are they? Well, the first power is, they can enter into contracts on behalf of the firm jointly. And, whenever there is, provision for jointness, it's naturally to keep, the check and balance, system in operation. The second, power was given to them was to operate the bank accounts of the firm jointly. Now, when Mufazzalur died, naturally, immediately the attempt should have been to induct another joint managing partner, so that, again, 2 persons together, can carry on the functions of the joint managing partner, jointly operate the bank account, and also, altogether participate in the business and affairs of the firm. But, that did not happen. Once, Mufazzalur died, Siraj, purporting to have the support of, the other 2 partners, that is Hamida and Intikab, which is the other group, circulated a resolution saying that the bank accounts have to be operated, so I ultimately vest in myself the power of operation of the bank account. That representation was that this is the temporary need of the firm. Naturally, things will be set right, because ultimately, there will have to be a reconstitution, and that is recognized in the letters itself. Now, so far as this is concerned, the petitioners repeatedly, raised questions as to how can you do this, and call for meetings of the partnership. Very important to note that, the partnership deed itself provides that, there will be a bi-monthly meeting held of the partners every month. They don't call us for a meeting. This resolution is not consequent on a meeting. It's a circular resolution that is circulated. And as a result, we are really kept in the dark. We keep writing to them that please explain to us as to why this is being done. Please participate in a meeting. Please let us take joint decisions. There was no response. In these circumstances, the petitioner partners, they purported to convene and call meetings so that the other partners could come, because the others were not calling the meetings. No response. Repeated letters, no response. Suddenly, this is followed up when these questions are asked and explanations are sought. Suddenly we are visited by a notice of show cause which purports to expel Miraj Usha, which is the petitioner number 1. Petition number 1 or 2? Petition number 1. Now, my lord, so far as is 1 or 2? I'm sorry, my lord, Miraj is the petitioner number 2. My lord, there's an attempt to expel Miraj. Miraj immediately, my lord, takes up that challenge, my lord, before this court in an application under Section 9. My lord, while the application under Section 9 is pending, my lord, they issue an expulsion order. My lord, that is, my lord, also brought on record by an affidavit, my lord, which the court, my lord, accepts and entertains, and my lord, proceeds to decide the matter holistically. My lord, considering the nature of charges on which, my lord, the purported expulsion was to be carried out, my lord, this court, my lord, forms the opinion that, my lord, this expulsion order is in bad faith. It is almost, my lord, like a fiat saying my way or the highway, my lord, these expressions are used, and, my lord, stays the expulsion order. My lord, that is carried in appeal. The appeal court, my lord, does not really interfere with the order. Matter is taken up to the Supreme Court. The Supreme Court does not interfere with the order, says that the arbitrator, who in the meantime comes to be appointed, will decide the matter, finally. With the stay in operation, the matter goes before the arbitrator. The arbitrator, my lord, ultimately decides that till the arbitration is over, there will be a stay on that expulsion order. Now, my lord, this apart, my lord, there was a second, my lord, reference that was also commenced, which was tagged with the first reference, and that was with regard to the affairs of the firm. What was the contention? The contention was that the partnership deed provides that it will have to be reconstituted following the death of a partner. So, my lord, there has to be a reconstitution, and you cannot purport to operate the bank account individually and cannot purport to, my lord, take all decisions individually to our exclusion. And, my lord, we had asked for a receiver. Now, my lord, there was a Section 17 there were several Section 17 applications filed before the learned arbitrator, which were disposed of by a common order. The common order said that at the moment I'm not appointing a receiver. I'm also not saying that the managing partner, because there's no joint managing partner now, Siraj Usha as the managing partner will not be able to perform any act or function apart from continuing to operate the bank account subject to furnishing of accounts. Well, one of the issues that was very grievous and was raised before both the court and the tribunal was that they had purported to use the funds of the firm to pay legal costs, to fight, the other partners, which, in law cannot be done. We had cited decisions, and, it was not, a paltry sum. As on the date of, filing the Section 17 application, more than 8 crores had been, expended on account of legal expenses. Now, that was the issue. Now, ultimately, whatever it is, the learned arbitrator says that you can continue to operate the bank account subject to, furnishing of accounts, but, no other order. No other power is arrogated to, the so-called surviving managing partner. Against that also, then appeal has been preferred. That appeal is pending, is being heard. Now, in the meantime, what is happening, naturally, we are going on asking for accounts. We are going on asking for, particulars. We are going on asking for who is doing the mining. Initially, the mining contractor was X. It was one of the firms of the partners themselves. That was substituted by one Tribeni without our knowledge or concurrence. And so far as that is concerned, Tribeni is again substituted by another partner. What is the name? Arttech. And what they do with Arttech is they purport to give him a share of the profits, which in fact ultimately amounts to transferring a part of the business. Now, we raise these concerns, and we also write to the ministry saying that please, we are not being given access to the books, papers, documents. We have no knowledge of what is happening in the firm. We have been excluded from its affairs altogether. So please ultimately see what is happening and take necessary steps. Because in the meantime, there are hundreds of crores that are due to the government on account of royalty. So that liability becomes liability of all the partners. So naturally, my concern is there. And I have myself invested to the capital of the firm a few hundred crores. Now, so far as this is concerned, now, there's a second show cause notice now that is served, which I shall take your lordship through on the 13th of April, 2026, where, they try to expel both Miraj, who is already expelled, subject to the final hearing. Of course, the expulsion is stayed, and the other brother Sarosh. What is the object? If these two are expelled, there's no one else to raise a voice of protest. So get rid of them. Now, expulsion order stayed, but expulsion not set aside, pending adjudication in arbitration. In the meantime, on the self-same allegations, which the court had found to be on bad faith, my lord, they proceed to issue a second show cause notice. We immediately, my lord, challenge that in section 9 before your lordship. My lord, again during the pendency, my lord, they proceed to say that we are giving you a last opportunity to file a reply. We naturally say we do not wish to file a reply because, my lord, the entire thing proceeds on bad faith. And, my lord, that is followed by an order of expulsion again. Now, my lord, may I, in this background, just show your lordship one or two things first. May I request your lordship to please have a look at the partnership deed between the parties once. That your lordship will find at page 81. Lord, if your lordship sees, my lord, here your lordship will find that at this juncture, well, the partners were, if your lordship sees page 81, Mufazzalur Rahman, who is dead. Then, my lord, your lordship will find the next partner is at page, yes, Mufazzalur Rahman. Then, my lord, in the same page, Hamida Khatun. She is not a working partner. Then, my lord, page 83, your lordship will find Muhammad Intekab Alam, then Sarosh Yazdani, and finally, your lordship will find, my lord, at page 85, Miraj Usha. Miraj and Sarosh are the petitioners before your lordship now. Now, my lord, please come to page 90. My lord, page 90, my lord, your lordship will find, my lord, at, my lord, the top, my lord, the partnership business shall, as reconstituted, shall continue to be carried out under the name and style of Sirajuddin and Company. My lord, please come to, I'm sorry, my lord, the top of the page. Now, my lord, this is the background. Whereas notice of expulsion of Muhammad Sarfaraz Alam, that is, my lord, another partner, has been duly notified to the registrar of firms in Kolkata for the erstwhile partnership deed, such and such. In the circumstances more fully stated, it has become necessary to reconstitute the partnership firm. And, my lord, the partnership firm is reconstituted. Now, my lord, why this is necessary or important is, my lord, earlier when a partner was expelled, the firm was immediately reconstituted. My lord, now a partner has died, but there is no reconstitution yet. My lord, 3 years have passed. Now, my lord, if your lordship sees, my lord, the relevant terms of the partnership, I shall take your lordship through, my lord, those terms. My lord, please have a look at, my lord, paragraph 11 at page 93. Upon the death of any partner, the partnership shall not be dissolved, and in the case of death of any partner, it shall be binding on the remaining partners to admit up to 3 legal heirs of the deceased partner in the continuing partnership. Notwithstanding anything contained, my lord, death of partners will not dissolve the firm. Then please see 13 at page 94. On the death or retirement of any partner during continuance of partnership or otherwise upon any partner ceasing to be a partner, or for any other reason, the firm shall not be dissolved, and in the case the legal heirs of any deceased or retiring partner not willing to join the partnership, in that case, the surviving partners shall have the option to purchase the share of the deceased or retiring partner in the partnership business. My lord, this is where reconstitution is again required. Then, my lord, the next clause, it is unanimously decided. Now, my lord, please note the word unanimously. This is very important. It is unanimously decided by all the partners here too that Muhammad Mufazzalur Rahman and Siraj Usha shall act as joint managing partners. The joint managing partners, namely Muhammad Mufazzalur Rahman and Siraj Usha, shall have power to negotiate with any agency relating to the affairs of the firm, for and on behalf of the firm, and all agreements or contracts executed by the firm shall be signed jointly by both joint managing partners, namely Mufazzalur Rahman and Siraj Usha, without which the document shall have no legal validity and shall be treated as invalid. My lord, important is, my lord, they are conferred only the power of joint, my lord, execution of contracts on behalf of the firm. And it says, my lord, without the signature of one, my lord, the document will be invalid. So, my lord, the system of check and balance is, my lord, very profound and clear here. Then 15, the joint managing partners, Mufazzalur and Siraj Usha, may delegate their power. My lord, this is not really relevant. In 16, my lord, Muhammad Intekab Alam, Sarosh Yazdani and Miraj Usha have agreed to keep themselves actively engaged in conducting the affairs of the partnership, and the said partners will also be the working partners of the firm. It is hereby agreed between the parties that as the aforesaid partners will be keeping themselves actively engaged in the business of the partnership firm, the working partners shall be entitled to remuneration. So, they are to keep themselves actively engaged in the business of the firm. Then your lordship will kindly come to clause 18. That for the smooth running of the partnership business, the joint managing partners, Muhammad Mufazzalur Rahman and Siraj Isha, are hereby jointly authorized by all the partners. My lord, kindly note, my lord, first, my lord, the unanimous authorization was, my lord, to the joint managing partners. And my lord, now paragraph 18 says, clause 18 says, joint authorization to operate the bank account by all the partners. For the smooth running of the partnership business, the joint managing partners, namely Muhammad Mufazzalur Rahman and Siraj Isha, are hereby jointly authorized by all the partners to open bank accounts in any bank or banks in India in the name of Sirajuddin and Company, which shall be operated jointly by the said two joint managing partners. All existing bank accounts of the different banks shall also be operated. So, my lord, what we have here is, my lord, there are two powers that are given to the joint managing partners, and these are given unanimously by all the partners. My lord, that is one, to, my lord, enter into contracts on behalf of the firm, and two is to, my lord, operate the bank accounts. Now, my lord, clause 19 is something that, my lord, is, my lord, very fundamental to partnerships. My lord, the concept of, my lord, just and faithful, my lord, between the partners. The partners shall be true, just and faithful to each other, and shall not do or cause to be done anything which is detrimental to the interests of the firm or prejudicial to the interests of the other partners. My lord, this, my lord, is, my lord, really section 9 of the Partnership Act, which says the same thing. My lord, then paragraph 20, my lord, this is the provision for expulsion. Parties hereto may decide to expel a partner on being satisfied that such delinquent partner is unjust and unfaithful to the other partners. So, my lord, it is unjust and unfaithful to the other partners, or are acting in a manner detrimental to the interests of the firm, or prejudicial to any of the partners, or has committed any fraud against the firm or any of its partners, or has committed any criminal offense or suffered, or has been guilty of any act, deed, or thing that would be ground for dissolution of the partnership. And in such cases, it shall be lawful for the other partners to issue notice to the offending partner to show cause as to why the offending partner should not be expelled. Then, my lord, will kindly skip over and come to 21. Again, your lordship will find, my lord, there is, my lord, agreement by all the partners. It is hereby agreed by all the partners that there shall be a meeting of the partners on every second week of every month to discuss or exchange views about the performance of the business and to lay out plans for future growth, and to take decisions in the meeting to the mutual benefit and advantage of the firm and the partners, and all decisions taken by a majority of the partners present at the meeting shall be binding upon the partners. Now, my lord, pausing here for a moment. So, my lord, there has to be a, my lord, meeting of the partners. Decisions have to be taken in such meeting and not otherwise. And, my lord, decisions may be, my lord, at these meetings, my lord, may be taken by majority. Now, my lord, so far as majority is concerned, my lord, the Partnership Act clearly says the majority rule will apply only in the case of, my lord, ordinary matters of day-to-day business of the firm. When, my lord, there are matters of import, such as, my lord, designation of a person as a joint managing partner, or authorizing him to operate the bank account, or, my lord, authorizing to operate the contract, this must be done by, my lord, the partners acting together with consensus. And that is why your lordship has seen the expression, my lord, clause 14 and clause 18 expression are unanimous and by all the partners. Now, my lord, these are the terms of the partnership deed with your lordship may be concerned. And, my lord, what is important is, my lord, the partners in this meeting at clause 21 must be partners present and voting at the meeting. So, my lord, even if majority rule is to be determined, it's to be determined on the basis of the partners present at the meeting and voting at the meeting. Now, my lord, this is the background. Now, your lordship will please see the first show cause notice that, my lord, had come to be, or, my lord, before that, may I just show your lordship one or two other documents. My lord, here, my lord, if your lordship sees, my lord, what, my lord, triggered the dispute between the parties, please come to page 224. My lord, this is, my lord, the letter that was sent, my lord, by one Pradeep Mishra, who is, my lord, acting as a spokesperson of, my lord, Siraj Isha. My lord, this is what it says. I am forwarding the resolution to be passed in circulation to resume the operation of the bank account and ensure continuity of the business of the firm. Kindly sign it as your consent for the proposal. No meeting held. And my lord, what is the resolution? Please see the next page. We record the sad demise of the joint managing partner of the firm, Mohammad Mufazzalur Rahman, on 16 June 2023. We record that Mohammad Mufazzalur Rahman, along with Siraj Usha, also joint managing partner of the firm, are jointly authorized to operate bank accounts of the firm under clause 18 of the partnership deed. We record that owing to the rapid deterioration of health of Mohammad Mufazzalur Rahman and his unfortunate and untimely demise thereafter, normal banking operations of the firm have come to a complete halt since 5th June 2023. Now, since 5th June 2023, it has come to a halt, and this is 22nd July 2023. In the meantime, no steps taken for reconstitution. We record that this had unprecedented adverse effect on the business operations of the firm, which has come to an absolute standstill and deeply affected the morale of the employees and other staff of the firm whose salaries could not be disbursed. We also record that on this account, the firm has not been able to make statutory payments to concerned authorities and now runs the increasing risk of legal exposure to various penalties under law, which need to be averted. That apart, the firm is unable to meet its business commitments to its trade partners and is facing increasing scrutiny of market reputation. We further record that the aforesaid persisting situation since 5th June has paralyzed the firm in all manner and affecting the overall welfare. Now, 5th June to July, 1 month has passed, no steps for reconstitution. We also record that following the death of Mohammad Mufazzalur Rahman, the firm needs to be, kindly note this, the firm needs to be reconstituted. This is an admission of the fact that reconstitution has to happen, which would happen in due course after discussions and deliberations amongst the existing partners and legal heirs of Mufazzalur Rahman. Mufazzalur Rahman's legal heirs have, in the year 2024 already signified, in July 2024 already said that they do not wish to be partners. That has been recorded by the arbitrator in the Section 17 order. Then, we further record that legal heirs of deceased joint managing partner Mufazzalur Rahman are also deliberating amongst themselves to take decision about joining the firm. Now, this is very important. We record that in the interregnum period, there is an urgent and immediate need to resume the banking business and operations of the firm. We further record that in these circumstances and in the best interest of the firm, its business, workforce, market reputation, it is resolved that the normal banking operations of the firm be resumed immediately by authorizing Siraj Usha as the sole signatory to operate the bank accounts of the firm with effect from the date of this resolution, such and such. Two things. One is, he says that there is exigency, bank operations have to be carried out. 1 month passed, no steps taken. He says that heirs of Mufazzalur Rahman deliberating as to whether they will join the partnership. In July 2024, 2 years back, they have signified, that they are not willing to join the partnership. Yet no reconstitution. And he says that this is only an interregnum measure, only a stopgap arrangement. Now continued indefinitely. Now, when these disputes were raised, I shall not trouble you with the rest of the papers, letters written saying that why are you doing this? Please hold a meeting. Please let us take a decision on this. I'll not trouble your lordship with all of these. But ultimately, this gives rise to the first show cause notice, which your lordship will find at page 246. Now, this is issued only to Miraj Usha, the petitioner number 2. This is the first show cause notice. I want to show your lordship what is, the basis of this notice. May I just, read portions of this document? I'll try to be, as concise as possible, but the matter is, of some expense. The present show cause notice issued in terms of clause 20 of the reconstituted partnership deed calls upon you to show cause as to why you should not be expelled. Then, paragraph 2, it has been noticed by majority of the partners who are also signatories to the present notice that you have been conducting yourself in material breach of the partnership deed and committed fraud against the firm in a manner considered unjust and unfaithful to the other partners and detrimental to the interests and business of the firm. Your conduct has been found to be unworthy of a partner and therefore posing serious threat. Now, so far as this is concerned, I'll not, go on reading. These are very generic, allegations that you are acting to the detriment of the firm. And then paragraph 3, it says, the partners are unanimously of the view that your conduct gives rise to grounds for expulsion. Now, there is no meeting held. The decisions will have to be taken in meeting. My lord, the other partner, my lord, that is Sarosh, who was still, my lord, undisputedly a partner, is not given notice of a meeting. And my lord, 3 partners purport to decide amongst themselves that we are going to expel him. So, my lord, they serve this notice. Now, my lord, what are the charges? Please see, my lord, the heading in bold at page 248. Unlawfully executing and signing loan-cum hypothecation agreements on behalf of the firm, violating the terms of the partnership deed. My lord, there is no, my lord, such loan-cum hypothecation agreement signed. My lord, what has been done is, my lord, certain guarantees were given, my lord, on behalf of the firm. Now, my lord, may I just explain this background without reading, my lord, too much into it? My lord, ultimately, this is there in the my lord, ultimately, my lord, what had happened is, my lord, so far as, my lord, the firm is concerned, since it carries out mining activities, it needs a fleet of trucks to carry out the mine door outside, my lord, the mining area. Now, my lord, the trucks, my lord, are not owned by the firm. They are owned by various trucking agencies. Now, there's a requirement by the government that you must increase the production in the mine. So, my lord, for that, my lord, further trucks had to be requisitioned and purchased. Now, my lord, the trucking companies with which the company was carrying on business did not have the requisite, my lord, security to offer to, my lord, the finance companies for the purpose. So, my lord, with the knowledge and consent of all the partners, some guarantee documents were executed saying that very well, these trucks that are being purchased by these, my lord, trucking companies, my lord, we will stand guarantor for that on behalf of the firm. This was executed by Miraj. Never the guarantee has been called upon. Guarantee is not invoked. Guarantee is not enforced. Guarantee is not encashed, and guarantee is ultimately discharged. And, my lord, after, my lord, please see here, my lord, they say that they have, my lord, observed in 2023, after the demise of Mohammad Mufazzur Rahman, that you have ultimately taken these decisions. Now, my lord, they do not raise any dispute with regard to this. Keep quiet. Why have you given guarantees on behalf of the firm? Finally, my lord, they choose to raise this dispute in this show cause notice. And, my lord, by that time, none of the guarantees are enforced, encashed, nothing has happened. Firm has not been put to any cost on that account. This is the first charge. Then, my lord, please see. Now, my lord, this charge is repeated in the current notice. Same charge, same. Although, my lord, this is under challenge, this has been found to be, my lord, in bad faith by, my lord, a judge of this honorable court, by the Supreme Court, my lord, no interference by the arbitrator. Then, my lord, please see, next, my lord, charge. Page 249, undermining the morale. Again repeated in this notice, undermining the morale of the senior employees, including auditors and other partners, by constantly defying or criticizing decisions taken by the majority of the partners. Well, today, if the majority partners don't, my lord, call meetings and purport to take decisions behind my back and anoint themselves with authority which they don't have under the partnership deed, I can't protest. If I protest, that's, my lord, a ground for my expulsion. Then please see, my lord, the next heading. Page 250, willful and malafide acts undertaken by you more specifically after the demise of the joint managing partners to obstruct the functioning of the working of the firm. Now, my lord, kindly see the vagueness of the allegations. Omnibus, opposing majority approved resolutions, creating hindrance in payment of salaries, wages. Not limited to that, after majority partners resolved that Siraj and, my lord, managing partner will look after banking operations, you've opposed this. My lord, this is the nature of the allegation. Now, my lord, then please come to page 253. Financial and operational irregularities committed by you to the firm, which ultimately led to huge loss in the firm. Well, let me just read this, very interesting. You as individual was vested with authority by the joint managing partners, made a decision that was neither appropriate nor business oriented. This decision involved appointing or authorizing 2 newly incorporated transport companies having no experience in transporting materials from mines. Upon closer scrutiny, it became evident that the management of both these companies are substantially influenced and controlled by you. Your actions led to severe conflict with local villages, etc. Now, my lord, they have said, the first line, you were vested with authority by the joint managing partners. You took a decision upon being vested with that authority. This has been going on. No attempt to, my lord, suspend or suspend business operations with these transporters. But, my lord, this is now made a ground for the expulsion. And, my lord, this is all that is there. Now, my lord, if your lordship now will come and have a look at the section 9 order that was passed on, my lord, this notice. My lord, if your lordship will please have a look at, my lord, page 264 first. My lord, this is the judgment of our court under section 9. My lord, if your lordship please sees, my lord, paragraph 5. This is how the first allegation is dealt with. The first allegation in the show cause notice dated 20th October 2023 is that Miraj unlawfully executed and signed loan cum hypothecation agreements on behalf of the firm in violation of the terms of the partnership deed. The specific allegations under this heading, however, show that the violation relates to all three agreements, which are dated 19th March 2021 and made in favor of Tata Motors Finance. One of the agreements was executed between Tata Motors Finance and Yazdani Steel and Power Limited. Miraj apparently signed on behalf of Yazdani Steel as the managing director and on behalf of the firm as guarantor. Allegation is that such act is illegal and in violation of the terms of the partnership deed. The facts disclosed in the pleadings, however, show that none of the three agreements dated 19th March 2021 were challenged by the respondents in the interregnum, which spanned more than 2.5 years. Surprisingly, the respondents have also not been able to show a single letter between March 2021 and October 2023 sent to the petitioner, bringing the complaint on record or questioning the petition on the same. Even more curious is the constitution of Yazdani Steel, which is one of the parties to the agreement. The petition discloses a statement which shows that Siraj, respondent 4, holds 10.68% shares in Yazdani Steel, and the respondents were directors in interconnected companies. Then, my lord, this is the first allegation, and my lord, then, my lord, the second allegation, paragraph 8. The second allegation in the show cause notice is the undermining of the morale of the senior employees. Then, my lord, paragraph 9, the show cause notice, however, does not disclose a single instance in corroboration of this allegation. Counsel appearing for the respondents argued that the petitioner Miraj opposed respondent before Siraj from taking over as the managing partner of the firm. It has also been submitted that Miraj opposed a few of the resolutions taken by majority partners. Even if such allegations are to be believed, it was incumbent on the respondents to disclose particulars in the show cause notice, which form the crux of the allegations. Then, my lord, the third allegation is that the petitioners malafide the acts after demise of joint managing partners of the firm, Muhammad Mufazzul Rahman. Although this heading is followed by 12 paragraphs, each of the allegations is couched in general and omnibus terms. Then the fourth allegation, paragraph 12, is of financial operation irregularities committed by petitioner and consequent loss suffered by the firm. Allegation under this head are also substantially general in nature. The reference to progressive logistics and responsibility logistics are not supported by particulars. Then, my lord, paragraph 16, my lord, your lordship will see, Section 33 of the Partnership Act expressly prohibits expulsion of a partner by the majority partners, save and except where the expulsion is done in good faith and in exercise of powers conferred by the partnership deed or contract. In the present case, the dispute is between 3:2 partners of the partnership firm. The petitioner Miraj is in the minority with the respondent number 3, Sarosh. Clause 20 of the reconstituted partnership deed dated 18 July 2019 empowers expulsion, but on factual satisfaction that the delinquent partner has been unjust and unfaithful to the other partners or has acted in a manner detrimental to the interests of the firm. The process of expulsion contemplated is through a notice to the offending partner to show cause. Majority partners may decide to expel the offending partner upon failure of the offending partner to show good cause. Offending partner shall thereafter cease to be a partner of the firm with immediate effect. The continuing partners shall have option to purchase the shares of the offending partner. Clause 20 of the reconstituted deed must be read along with Section 33 of this, with Section 9 of the Partnership Act, which forms the moral compass of the duty of the partners to be just and faithful to each other and to carry on the business of the firm to the greatest common advantage. The opposing respondents must therefore follow the satisfaction requirement of Clause 20 of the deed with the greatest probity. It is not merely a question of my way or the highway, where one partner commands and the other partner silently obeys, but a collective responsibility to conform to the trust and faith obligations of one partner to the other. The material disclosed shows that the tussle between the two groups is presently on account of minority refusing to toe the line of the majority. In fact, the letter of expulsion used this expression. Submissions made on behalf of the parties also make it clear that the petitioner refused to backslap the respondents on the resolutions and decisions taken by the majority or remain a mute spectator to these decisions. It appears that Clause 20 was pressed into service to rid the firm of a vociferous and defiant opponent. Even if the allegations made in the impugned show cause notice and the notice of expulsion are taken to be true, the respondent's obligation to fulfill the good faith requirement of Section 33 of the Act remains. The respondent must discharge the burden of proving that there were indeed good reasons to issue the show cause notice and thereafter to expel the petitioner. This would require at least a modicum of evidence or particulars in both the impugned notices and justification for expulsion. The statutory benchmark of good faith under Section 33 of the Act also presupposes fulfillment of the principles of natural justice. The opposing respondents say that the show cause notice dated such and such was received, etc. This can be, my lord, ignored. Then, my lord, please see, my lord, 27, paragraph 27. My lord, this discusses, my lord, the good faith cases, that, my lord, there is an obligation to act in good faith. And then, my lord, 28, my lord, 28, my lord, towards the middle of the paragraph, the allegations, repeats of those made in the show cause notice and the expulsion, the opposing respondents have taken a lord and master approach where all dissent is to be summarily stifled. My lord, this was the order on the basis of which, my lord, stay was granted. My lord, then, my lord, this was taken up in appeal, my lord, before a division bench. My lord, the division bench order I shall not place before your lordship. My lord, ultimately the matter reaches the Supreme Court. My lord, Supreme Court orders at page 270.
Supreme Court is 270.
Yes, my lord, 270 is the Supreme Court order. My lord, paragraph 5, my lord, notes the division bench order. My lord, sends it, my lord, appoints an arbitrator, and my lord, sends the matter to the arbitrator for decision under Section 17. So, my lord, there is no interference with the order of the learned single judge. And now, my lord, if your lordship sees, my lord, the order of the learned arbitrator on this aspect of the matter, my lord, that your lordship will find at page 302. My lord, both applications were taken up. My lord, since I am showing you, sorry, it's 306, no? 306, I think. Huh? I'm sorry, my lord, it's page 276, my mistake. 276. Well, I'll not trouble your lordship with, my lord, all that has been stated here. My lord, may I just show your lordship, my lord, the portion which continues, my lord, the order. My lord, internal page 14, my lord, your lordship will kindly have a look at. No. No. The internal page 14 to me.
Page.
Well, kindly give me a moment, my lord. There seems to be, my lord, some difficulty with regard to the pages. Well, kindly just give me.
This is the correction order. Supplementary to that, right? This is the correction order, not the main order.
Oh.
Supplementary to that. Right.
That main order is not there.
No. It's corrected. There's the correction order.
My lord, the order, my lord, is, my lord, the correction order is there, my lord, in the petition. My lord, the main order, my lord, of the learned arbitrator, my lord, is in the supplementary affidavit. My lord, we had prepared the supplementary. Kindly allow me to, my lord, hand it up. We have served the copy. Well, your lordship will please see. Well, it starts at page 7A. Well, I'll not trouble your lordship with the background at all. My lord, please have a look at, my lord, page 20. Running page 20. Well, at page 20 at the top. Well, after discussing some of the facts, the arbitrator notes, second paragraph, the claimant has made out a good prima facie case of procedural infraction in the expulsion of the claimant by reason of haste and inadequate time to the claimant to effectively respond to the show cause notice. The balance of convenience is in favor of the interim protection to the claimant, as otherwise the majority partners may take such further action which will render the arbitration infructuous. Furthermore, unless the stay of the show cause notice and the decision dated 15th November 2023 to expel the claimant from the firm is continued to the disposal of the arbitration proceedings, the claimant will not be paid his remuneration, etc. Then, my lord, the show cause notice dated 20th October 23 and the decision dated 15th November 2023 to expel the claimant from the firm is therefore stayed till the disposal of the arbitration proceedings. And, my lord, then please see, my lord, 2 paragraphs thereafter starts with the words until such time.
This is noted after noting clause 21. Yes.
Now, my lord, this notices clause 21 of the deed of partnership. May I read the next paragraph? Clause 21 of the deed of partnership requires that a meeting of the partners should be held every month in the second week to discuss or exchange views about the performance of business and to lay out plans for future growth and to take decisions in the meeting to the mutual benefit and advantage of the firm and the partners. However, all decisions taken by the majority of the partners present at the meeting shall be binding upon the partners. Until such time as the deed of partnership is reconstituted and new terms and conditions govern the partnership, meetings of the partners shall be held in the second week of every month. It will be open to the claimant to attend such meetings until and unless orders to the contrary are passed by this arbitral tribunal. And then, my lord, if your lordship sees,
Section 37, there was a direction that meetings be convened through a special officer. Reconvene the meeting, do not participate. So their majority is.
Now, my lord, then if your lordship sees the next paragraph, my lord, talks about operation of, my lord, the bank account of the firm, etc. Now, my lord, this is what we were aggrieved by and we have challenged it, my lord, before this honorable court. It is pending in appeal before a division bench. Now, my lord, this is, my lord, the operative portion at page 21 in bold. In the circumstances, this tribunal directs that until the reconstitution of the firm and the imposition of new terms and conditions governing the partnership firm, the respondent number 4, my lord, this is the managing partner, may continue to operate the bank accounts unless orders to the contrary are passed by this tribunal. The claimant or the respondent number 3 shall not interfere with the operation of the bank account by the respondent number 4. However, as agreed by the respondent numbers 1, 2, and 4, the respondent shall maintain separate accounts of all transactions and shall furnish accounts of all transactions to the claimant of weekly basis. So, my lord, what is very important is, well, lord, apart from staying the order of expulsion, this order says, my lord, so far as the, my lord, managing partner is concerned, there's no concept of a managing partner. It's only joint managing partner under the deed. My lord, he will only now, my lord, operate the bank account, nothing more. Now, my lord, so far as this order is concerned, my lord, thereafter, my lord, your lordship see, my lord, there are disputes in arbitration. There are further, my lord, acts of, my lord, bad faith, which we have challenged, my lord, in a separate section 17 application before the arbitrator. That is pending consideration. Now, my lord, if your lordship will now come to the fresh show cause notice. Now, lord, before I show your lordship the fresh show cause notice, which is at page 30, well, I just need to, my lord, make 2 statements. One is, well, the fresh show cause notice is also a notice that has to be issued upon holding a meeting of the partners of the firm.
And testing majority present.
And, my lord, the testing, my lord, applying the test of majority, my lord, present in voting. Well, it's first. Secondly, my lord, so far as this is concerned, what is again very, very important is that, my lord, ultimately, the court had directed, the arbitrator had directed that you will reconstitute the firm. And it is only pending reconstitution of the firm that ultimately you can just operate the bank account, subject to maintaining accounts. Now, my lord, so far as the order of the court is concerned, my lord, that order your lordship has find was dated, my lord, section 9 order was dated on the 1st of September 2024. Now, my lord, we are then a section on arbitrator's order. Arbitrator's order is, my lord, 1st of September 2024. Now, my lord, naturally, my lord, again, they are finding it very inconvenient because, my lord, we are questioning all their acts and motives without holding a single meeting of the partners. My lord, they now decide that we must get rid of the opposition once and for all. So not only Miraj, but get rid of Siraj also. Sarosh also. Now, my lord, please have a look at this show cause notice. It starts at page 30. Now, this is issued to Sarosh and to Miraj. This is a formal notice issued to you, Sarosh Yazdan and Miraj Usha, by and on behalf of the other partners of Sirajuddin and Company, calling upon both of you to individually explain under show cause as to why appropriate action should not be taken against you on account of your wrongful actions, activities, etc. Both of you have been acting in total breach of your obligations as partner, and it is apparent now that you are maliciously conspiring to undermine and destroy the very foundation of the firm by trying to obstruct its banking operations. Well, there has been no event of obstruction, hatching evil designs, and have its mining lease cancelled. Before setting out the particulars of wrongful actions and conduct on your part complained herein, we feel constrained to express that we are shocked and surprised by your drastic attempts to sabotage the business of the firm. Now, please have a look at what are the charges. Please come to paragraph 6, page 32. Particulars of incidents and actions concerning Sarosh Yazdan. This is other part. Despite being well aware of the misdeeds and illegal actions of Miraj Usha, you, Sarosh Yazdani, chose to turn a blind eye to the same. And in fact, I am reading at page 32
of the supplement
of the petition. This is the second show cause notice. Show cause notice under challenge. Now, what is very interesting is what you will see. First, let us see the charges against. The first page is at page 30. Now, if your lordship will straight away come to the particulars of the charges. First against Sarosh. Please see, how manifestly unjust this is. Despite being well aware of the misdeeds and illegal actions of Miraj Usha, the first partner who was sought to be expelled, you, Sarosh, chose to turn a blind eye to the same and in fact tried to support him in all his actions, even when it was not in the interests of the firm to do so. We have repeatedly requested you not to connive with Miraj in his unlawful, unethical and prejudicial acts, but to our dismay you did not heed our warnings and continued to conspire and collude with Miraj in perpetuating unlawful, unethical and unjust actions against the firm. Moreover, you have also independently, consciously, deliberately indulged in further nefarious illegal actions which are clearly adverse to the interests of the firm, gravely hampered. Now, so far as this is concerned, you say you have sided with Miraj, so you have done something grievously wrong. Then, next charge, purporting to raise frivolous objections regarding the engagement of Arthtech Earthwork LLP as the raising screening contractor. Now, today, this Arthtech is appointed by Siraj acting by himself. As the joint managing partner, he was supposed to act along with the other joint managing partner. Once the other joint managing partner dies, he is supposed to reconstitute the firm, which he does not do. He purposed to take a decision to appoint one Arthtech Earthwork LLP as the mining contractor without any meeting, without our knowledge, without our concurrence, without our approval, nothing. Now, it says that because you have tried to raise objections with regard to the engagement of Arthtech, you need to be expelled. During the period of 2020 to 2022, Sarosh Aliza Mining was appointed raising contractor, etc., etc. I will not trouble your lordship. Then, if your lordship will kindly come to 7.3. Thereafter, in the usual course of business, Messrs. Arthtech Earthwork LLP was appointed. Now, if your lordship pauses here for a moment, there was no meeting held, no discussion, my lord, invited, no discussion held. Arthtech Earthwork is appointed as the raising contractor without, my lord, any participation of the other partners. And then what it says, thereafter, in the usual course of business, Arthtech Earthwork LLP was appointed as the raising contractor and the production in the mines commenced. However, when the said firm decided to issue fresh work order in favor of the raising contractor Arthtech Earthwork in view of the extended scope of work and sought to intimate all the partners about the same, kindly mark, sought to intimate the partners about the same. So, unilateral decision, not, my lord, invite their, my lord, views. Sarosh Yazdani seized the opportunity to claim that instead of issuing fresh work order to the contractor, work ought to be assigned to Sam. Well, there is no documentary evidence to this effect. It is pertinent to note that such fresh work order was necessary to ensure that the firm reaches and fulfills its minimum production target and mandatory dispatch requirement under the MMDR Act and rules, and to ensure that Arthtech Earthwork, unlike Sarosh, manages to meet the minimum production target. Then 7.5. However, on receipt of the draft work order which was to be issued to Architect with the extended scope of work, Sarosh Yazdani wrote to the firm requesting the firm to give Sam the opportunity of working the mines in place of Architect, ignoring the fact that Sarosh Ali's mining performance had been bad. Then, my lord, thereafter, we received a response, 7.6, from Sarosh by an email supported by Miraj. All your concerns and requests raised in the emails were addressed by the remaining partners. Now, my lord, I'm trying to look for the charge. It will appear from the aforementioned fact that Sarosh Yazdani is deliberately acting to the prejudice of the firm. You're trying to interfere with the business of the firm in order to profit personally. Then, my lord, 7.8. When the firm declined the proposal for reinstating Sam as the raising contractor on account of its incompetency, outstanding dues, etc., both of you retaliated in writing by writing frivolous letters and correspondence to, my lord, the government of Orissa and authorities. My lord, may I pause here for a moment? So what is the charge? The charge here is that you objected to the appointment of Architect, my lord, or not appointed through a partners meeting. You object to, my lord, the extension of its scope of work, my lord, again, my lord, without any discussion of the partners. And, my lord, you said that you wanted to be reappointed as a mining contractor. Well, I was earlier the mining contractor, Sam, Sarosh Aliza Mining. You wanted to reappointment, so it's an act of bad faith, you have to be expelled. Now, my lord, so far as the writing of letters to the government of Orissa is concerned, well, I shall take your lordship to the letters, but, my lord, let us see, my lord, what is being done. Then the next allegation, deliberately making false and scandalous statements about the firm to various important authorities. Well, I shall not trouble your lordship with this. Well, lord, please see. Well, lord, this is, my lord, where really the charge against, my lord, Sarosh ends. Well, lord, they have made, my lord, various, my lord, allegations which are, my lord, very generic and general in nature. Then, my lord, if your lordship sees, my lord, clause 17 at page 45. Other acts impeding the partnership from carrying out its business transaction. Now, my lord, here, my lord, very interestingly, may I just read this? Prior to the above mentioned misdeed, you also, along with your fellow partner Miraj Usha, by your respective letters dated such and such, misrepresented before the partnership firm that the dues of Yazdani Steel and Yazdani International and Sirajuddin and Company be adjusted against yours and Miraj Usha's purported imaginary cash advance. You have gone forward and in connivance with Miraj Usha have taken out proceedings before the adjudicating authority to withdraw CRP. My lord, may I just pause here instead of, my lord, troubling your lordship with, my lord, these, my lord, plethora of, my lord, facts. My lord, what had happened? My lord, first charges you have, my lord, supported Miraj. The second charges you have objected to the appointment of Architect.
Yeah, but why don't you challenge it in your section 9 before the arbitrator?
My lord, the problem is, my lord, this is a fresh cause of action. I have already given a notice.
Even if it's a fresh cause of action, the arbitrator has already been appointed. The arbitral tribunal is
No, my
there.
lord, arbitrator has been appointed in the other reference. Now, my lord, here, so far as this is concerned, the law says that if it is a fresh cause of action, my lord, there will have to be a fresh reference, maybe to the same arbitrator. Now, my lord, that is why, my lord, because we have already issued a section 21.
Arising out of the same contract, the same agreement. Why fresh cause of action?
Well, it is a fresh agreement, but, my lord, this is a fresh notice of, my lord, expulsion.
That's right, but the notice could have been taken.
My lord, we have to then amend the arbitration, my lord, records because, my lord, the challenge in the first reference is only to, my lord, Miraj's expulsion.
That's all right, but by way of a section 9, you can take this there.
Well, at section 9, my lord, that is why I've come up. Well, at
Section 17.
17, my lord, section 17, my lord, section 17, my lord, my lord, would have, my lord, ordinarily taken. If my learned friends, my lord, say that, my lord, they will admit that this to be a part of the same reference, and, my lord, I shall be at liberty to move a section 17 before the arbitrator, my lord, I can do that. But, my lord, what they have purported to do is to, my lord, exclude me altogether, lock, stock, and barrel. Now, my lord, all that I'm saying here, my lord, I am, my lord, of the opinion that, my lord, this is a fresh cause of action. I will have to make a fresh reference where I challenge the new, my lord, order of expulsion by which, my lord, Miraj has been sought to be expelled twice over and Sarosh has been sought to be expelled.
Dispute which is arising out between the parties is related to the contract, the main contract.
Yes.
Just to give it a color of a fresh exercise, that will not really bring you out of the mandate of the arbitration proceedings.
Well, if my learned friends say that, this may be treated to be a part of the fresh reference of the same reference, then I can move the section 17 there.
Send it, sir. We can send it back.
But my learned friend should not then take the point before the learned arbitrator that there is no reference pending with regard to this show cause notice.
Let this application be treated as a 17 before the learned arbitrator.
I'll tell your lordships what happened. They are treating it as a fresh reference. Be that as it may. They've given us a 21 notice, my lord, on Saturday. Wait 1 minute. First, now, my lord, that 21 notice, certain pages were missing. We requested for that. My lord, those have been provided. Now, my lord, they want, my lord, the reference to be made to the same learned arbitrator. Now, my lord, I've asked them to take instructions whether we are agreeable or not. Yes, my lord, we are, my lord, agreeable to, my lord, going before the, my lord, the learned arbitrator. Your lordships can record it. And, my lord, the 17 can...
Well, in that case, my lord, we kindly, my lord, record that my learned friends have no objection. My lord, this will be then a fresh reference.
And what I'll record is that you have moved to section 9.
Yes.
The parties have consented that this should be treated as a section 17 before the learned arbitrator. All the disputes arising out will be left open to the arbitrator.
Only one, my lord, small difficulty. My lord, after an arbitrator is appointed, my lord, section 17, my lord, can be moved. Your lords will record that my learned friends, my lord, consent to, my lord, a fresh reference in regard to this, my lord, dispute to be made to the same arbitrator. So that, my lord, we can take this, my lord, as an application under section 17.
All right.
Whether it's the same or different.
They'll have to make a fresh application.
But if my learned friends agree to that,
yes,
I can take it before the arbitrator. Because, my lord, that learned arbitrator is at least, my lord, acquainted with, my lord, these disputes to a certain extent.
I know, my lord, how both sides are, my lord, litigating.
In the
relatives, my lord, everybody. Some are, my lord.
There's some,
my lord, there are one section, my lord, has two brothers on one side and
correct,
one, my lord, on the other.
Right.
And the others are, my lord, cousins.
But in the meantime, my lord, let them not give effect to, my lord, the expulsion order.
That I will not.
No reply has been given.
That I will not.
My learned friends say that no reply has been given. What reply do I give to these allegations? My lord, your lordship will, my lord, then may I make a request, my lord, your lordship will, my lord, say that, my lord, this matters may be agitated before the learned arbitrator upon treating this to be a fresh reference. By consent of the parties, my lord, these disputes are referred to, my lord, the learned arbitrator. Because my learned friends have agreed, my lord, this can be, my lord, treated as a fresh reference before the arbitrator, and this application will be treated as a section 17 application with only one request, my lord, if the learned arbitrator can take it up expeditiously.
That is for him. The petitioner has preferred to present petition
Huh?
of the arbitration and conciliation of 1990.
Well, the section 17, my lord, 21 notice, my lord, may I just hand up?
Sorry.
Yes.
My lord, if your lordships take, my lord, the section 21 notice on
Yes,
record,
ma'am,
and my lord, record our submission that we are agreeing.
well, may I hand up a copy of the notice, my lord?
Challenging the show cause notice dated 13th April 2023. At the outset, learned counsel for the parties, learned senior counsel for the petitioner, Vishnu Saha, as well as the learned senior counsel for the respondent, Mr. Mukherjee, consent to the present petition being treated as a section 17 before the learned arbitrator. Learned senior counsel for the petitioner raises the apprehension that since this is a separate cause of action, a new reference needs to be entered into before the arbitrator. Learned senior counsel has issued a section 21 notice dated 17/5/2026 to the respondent agitating the fresh cause of action in terms of the agreement. There's the first agreement. What is the date of the agreement?
Your lordship wants me with the date of the so-called notice, it's
In
30th
terms
April
of the partnership date agreement, partnership date,
18th July
2019. Full stop. Learned counsel, learned senior counsel for the respondent states that the present dispute can be treated as a separate cause of action before the same arbitrator and consents to the appointment of the same arbitrator to adjudicate the dispute between the parties. As a separate cause of action, since the show cause notice dated 13th April 2026 is to be treated as a separate issue. Full stop. Both the parties consent to the fact that the dispute arises out of the partnership dated 18 July 2019, and that already a reference has been entered into by the learned arbitrator in terms of the arbitration clause as contained in the partnership deed. In view of the same, the present dispute can be treated as a separate cause of action to be adjudicated upon by the same learned arbitrator. In view of the concession made by the counsel for the parties, this court refers the matter to the learned sole arbitrator to adjudicate the dispute regarding the termination dated 13/4/2026.
Expulsion.
As well as the expulsion.
It's 11th May 2026. So cause notice was
13th
13th April.
And the foregoing action of expulsion dated
11th May 2026.
11th May 2026 as a reference before the learned arbitrator. Full stop. This present Section 9 application shall be treated as a Section 17 application before the learned arbitrator.
Present Section 9 along with the supplementary affidavit.
Along with the supplementary affidavit to be treated as a Section 17 application to be adjudicated by the learned sole arbitrator in accordance with law. Full stop. Anything else?
No, Malay, I think this will suffice. Malay, since we have given the Section 21 notice and my learned friends have agreed to the appointment to the arbitrator.
Yeah, they're cutting short the whole 11 process.
Yes, Malay, very well.
To our detriment.
With the opposite direction, the present application.
I don't understand why it is to Mr. Mukherjee's detriment because he's also appearing in the arbitration. So it's not to his detriment.
Because of 11, one stage. That's why, to his detriment.
Grateful.
Disclosed. Affidavit of service and notice of action is taken.
Grateful, yes.
Your Lordship, in item 38, I am for the petitioner. Your Lordship, pursuant to Your Lordship's direction, we had made a paper publication because the respondent were not appearing in spite of notice by email and by post. Your Lordship, the agreement arbitration clause is at page 35, clause 24, wherein three arbitrators are to be adjudicate upon the matter. Our named arbitrator, section 21 notice is at page 93. We had named our arbitrator. They failed to correspond to even reply to even the section 21. Our named arbitrator and a nominee arbitrator may be appointed by Your Lordship, and both may appoint the third arbitrator.
The paper publication.
Lordship, on the last occasion, yes, Your Lordship, the paper publication.
Which page is that? The agreement?
Agreement starts at page 24. The relevant clause, clause 24, is at page 35.
The present application. Petitioner has preferred the present application under section 11(6) of the Arbitration and Conciliation Act 1995, seeking appointment of a nominee arbitrator on behalf of the respondent who has to enable the constitution of an arbitral tribunal for adjudication of the dispute between the parties. Learned counsel for the petitioner submits that the parties entered into a power supply agreement dated 24/5/2006 for supply of electricity in bulk from major thermal power station of the petitioner to the project site of the respondent, situated at village Nandanpur, Mauza, Ramkrishnpur, EO Ranipur, PS Mejia, District Bankura, West Bengal, for a period of 5 years. Learned counsel for the petitioner submits that the respondent was irregular in payment towards the electricity consumption charges. Hence, the electricity connection was disconnected in November 2013. Full stop. It is further stated that the tariffs determined by the West Bengal Electricity Regulatory Commission
on 19th of June 2020, the Tariff Regulatory Commission gave the final tariff, Your Lordship, which we have stated at page 50.
It is further submitted that in view of the new tariff connection given by the West Bengal Electricity Regulatory Commission, the petitioner raised a differential tariff claim for the period 2006 to 13 by issuing a bill on 1/1/2021, right?
Your Lordship.
1/1/2021. According to the petitioner, there is an outstanding amount of 1,187,33906. Full stop. Learned Counsel for the petitioner further submits that the petitioner issued a notice dated 27/2/2025 under section 21 of the Arbitration and Conciliation Act 1996, invoking clause 24 of the power supply agreement dated 24/5/2020. 2006. Full stop. The petitioner nominated Surinder Kumar as its nominee director arbitrator. Full stop. Despite receipt of the notice, the respondent failed to nominate its arbitrator. In the aforesaid circumstances, the petitioner has approached his court seeking appointment of a nominee arbitrator on behalf of the respondent so that the nominee arbitrator and the arbitrator of the petitioner can appoint a presiding arbitrator to adjudicate the dispute between the parties in terms of the arbitration clause. Full stop. The dispute between the parties arise out of the alleged default in clearing the outstanding amount arising out of the power supply agreement dated 24/5/2006. Full stop. The notice invoking arbitration was duly issued on 27/2/2025. Full stop. Prima facie, it appears that the dispute between the parties have arisen out of the power supply agreement dated 24/5/2006, which contains an arbitration clause, being clause 24 thereof. Full stop. However, despite receipt of the notice, the respondent failed to nominate the arbitrator. Full stop. First line लिख देना, the respondent, despite paper publication, none appears on behalf of the respondent. First line. Accordingly, this court is satisfied that the present case is a fit case for reference to arbitration. Accordingly, this court appoints. Give a name. Anybody? Some senior person has to be appointed, or a retired judge, Ms. Pandey.
Your Lordship, a senior person may be appointed and both can thereafter appoint a retired judge. Mr. Shako Sen, senior advocate, is dealing with few of the DVC matters. If Your Lordship so pleases.
He's arbitrator or he's...
As an arbitrator. As an arbitrator. In two matters, he is already dealing for one appointed by the court or anybody Your Lordship pleases.
Court appoints Mr. Shako Sen, learned senior counsel, as the nominee arbitrator on behalf of the respondent to adjudicate upon the dispute between the parties. Both the nominated arbitrators are requested to take immediate steps for appointment of the presiding arbitrator in terms of the arbitration clause contained in the power supply agreement dated 24/5/2006. Full stop. All questions relating to arbitrability of the dispute, admissibility of the claim, limitation and other issues are kept open to be urged before the arbitral tribunal. Full stop. The appointment of the nominee arbitrator shall be subject to compliance with section 12 of the Arbitration and Conciliation Act 1996. Full stop. After the constitution of the arbitral tribunal, the learned arbitrator shall fix his remuneration in terms of the fourth schedule of the said act. Full stop. The order of this court shall be communicated to the learned sole arbitrator to take necessary steps. Full stop. With the aforesaid direction, the present petition stands disposed of.
Obliged, Your Lordship. Your Lordship had asked me, I had requested that a sole arbitrator may be appointed. I researched on that point. There's no judgment on the point that whether the numbers can be changed. Though in Indian Oil, when the independence is in question, then it can be.
To the parties, it can be.
Your Lordship. With consent, but without consent, it can be. I couldn't find any judgment on that. Obliged.
May it please, my lord. I appear for the petitioner. This is my section 11. Today is the
Lordship,
fifth.
I beg to appear. Lordship, praying for my lord's leave to appear virtually, my lord, for the respondents 1, 2, 3, my lord.
May I file my affidavit of
Are you
service? Then?
disputing?
My lord, we are disputing this, my lord, on this score, my lord. My instructions are, my lord, that an amount of bill value of rupees 20 lakh
Oh,
44.
no, sir, Mr. Mishra, are you disputing the agreement? Or
No,
the,
no, no, my lord. We are not disputing the agreement, my lord.
Then go before the arbitrator,
Yes.
whatever the issue is.
Very well, my lord. Very well, my lord.
The petitioner has preferred the present petition.
Lord, just one more thing, Lord. That since the clause contains 3 arbitrators, your lordship, with his consent, Lord, may a sole arbitrator be appointed. The sum
Very
is
well, my lord. A sole arbitrator can be appointed. The
Sum is
amount is
very
very initial, my lord. 3 arbitrator. My lord, they are claiming the amount of rupees 1 crore and odd, which is due and payable. But my instruction are 20 lakh is there and which has been lying with us, my lord. They can take at any time, my
May
lord.
that submission be recorded also. We'll take a-
Arising out of a contract dated 27/1/2025 containing an arbitration clause 64(1) of the Indian Railway Standard General Conditions of Contract. 64(1). That's the clause 64(1).
Yes, my lord. Yes, my
Yes, my
lord.
lord. 64(1) is the arbitration clause in GCC, my lord.
64.1.
64.1.
Point
Point
1.
1.
1 is in brackets.
And point 1 in bracket. Full stop. Without getting into the merit of the matter, learned counsel for the parties state that do not dispute the arbitration, do not dispute the agreement as well as the arbitration clause contained in the agreement. They suggest a name, both of you.
My lord, senior advocate may be appointed, my lord.
Ms. Less, my lord. Mr. Sarvopriya Mukherjee may be appointed.
20 lakhs, which senior advocate will do?
My lord, may I suggest a name subject to my lord's permission, my lord?
Suggest a name.
My lord, Mr. Aniruddha Mitro, senior advocate, can be appointed, my lord.
Yes.
Their claim is 1 crore. If my lord.
Yes, my lord. I
All right. Learned counsel for the parties mutually suggest the name of the learned sole arbitrator,
Mr.
Aniruddha
Mitra.
Aniruddha Mitro, my lord.
Give the number.
Yes. Aniruddha sir, number ta diye. I want
The
to
parties have jointly agreed to the appointment of the learned sole arbitrator. This court appoints Mr. Aniruddha Mitra as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall enter the reference after due compliance with Section 12 of the Arbitration and Conciliation Act. After constitution of the arbitral tribunal, the remuneration shall be fixed in accordance with the 4th schedule of the Act. Full stop. A copy of this order shall be communicated to the learned sole arbitrator to take necessary steps. उससे पहले एक लाइन लिख देना. Learned counsel for the arbitration clause contained herein. Learned counsel for the parties with the consent state that a sole arbitrator shall be appointed to adjudicate the dispute between the parties. In view of the prayer made by the counsel for the parties, sole arbitrator Mr. So and so is appointed. ऊपर ही डाल देना.
Grateful, my lord. With my lord's leave.
Affidavit service taken.
Section 11 application, Lordship. Lordship,
Not today, day after.
Lordship, some difficulty then entire week I
After.
Immediately after, because Lordship recollects that this was an issue where Section 16 was passed suo motu without there being a Section 16 application, which was set aside by this court.
10th
And
of June, 10th of June.
yes. Huh? Lordship, the affidavit reply be kept on record.
Affidavit of reply
Date down.
filed by
Date down or calendar to work on.
is this matter on 10th of June.
Lordship, की बात होती है? Lordship, instead of 10th, can it be 11th of June?
11th is Thursday. 11th won't.
12th,
You can have it 15th or 17th.
15th of June. 15th.
15th of
Highly obliged.
Forty-one, I'm for the petition. Not pursuant to your lordship's last order, I have effected a fresh service upon the respondent.
But I have received the application.
Yes.
I would, well, at time of which I would request Lordship to adjourn this matter for a while because they have obtained an ex parte order under Section 9 that before Raja had commercial court in the month of January. Till date, that I have not been served. I have got the copy of the order annexed to this
a
application.
different proceeding.
The only thing is, if Lordship appoints an arbitrator, then that order which they have obtained ex parte and did not disclose till this date will be constituted to be continued in the arbitration proceeding as well. And I'll be prejudiced. I'll be seeking vacating of that order before that court.
That's
Today I
a
have been
separate proceeding, sir. Has got nothing to do with your Section 11.
Once the tribunal is constituted, the
Yes.
court will its forum, then the tribunal will
They will file a whatever Section 17 before the tribunal.
kindly record that order will not continue after this.
I don't need to record anything as far as that order is concerned.
I am
Are you
really concerned with that, because that
You are
ex parte
concerned
order
with
not
that?
served upon me ever.
Once the arbitrator is appointed, you raise all your concern before the arbitrator.
Well, only thing it should not be considered that ex parte order will continue after the.
Obviously, that ex parte will not continue after the tribunal is.
Yes, that is the only clarification.
That you have to do before the tribunal, not before me.
No, I am only saying if logically clarifies that.
No, I'm not going to clarify anything. Section 9, why should I make any comment?
I'm not the other.
Are you disputing there's only two things which I need to say. Are you disputing the agreement? I dispute.
Agreement is unstamped and unregistered. That's the point.
It is all these issues
Yes.
you take it before the arbitration.
Only one thing, since it's a question of money. They are so if Lordship gives us some time, whereby I have taken instruction from my client that we can resolve this without in a mediation proceeding or otherwise we can try to resolve it without going to the arbitration process. That is a
We are seeking specific performance specifically.
Big performance, how can that be resolved?
they have read the. If the issue is I have received some money from them, have not handed over the property. That's their case.
He's
That is
asking
why I
for
can refund
specific performance of the agreement, then there's no question of return of money.
Lordship would kindly come to page 30, 32 of the petition,
Page 56, my lord.
32 has a clause 12. If they fail to pay the remaining part, I can refund. But my case is that they have failed, so I want to refund and finish it off. There is no. But if I go for arbitration, then the same offer I will make in arbitration proceeding also. Clause 12(1), if they fail to pay, I can refund.
That's page 56, paragraph number 4.
So that is, if they have not, according to them, they have paid 30 lakhs, they are supposed to pay 39 lakhs. They have not paid 9 lakhs within the time. So I can refund and finish it off. The dispute will come to an end.
Yes.
I have to take instruction.
Take instruction, come back. Day after tomorrow.
My lord.
Not today.
But my application, it's under Section 11. But I believe someone had appeared on the last day and they had said they want to file an affidavit, but your lordship had said your lordship will consider on the last day. I'll just tell your lordship now.
By senior counsel, so it should ask short password.
Password won't be possible.
But there is section 9 in which your lordship had passed an order, but the order has been extended any number of times. No opposition has been filed by them, Lord, in the section 9
Day after
in
tomorrow,
5 minutes. Very
Day after tomorrow. 23.
Interim order expires during the vacation in case the
Day
matter.
after tomorrow.
No,
We'll extend it.
that's a different item. That's not
I know,
this
I
one.
know.
But the other item may appear along with it. That's item number 53. That's the connected section 9.
Both the matters, 40,
42 and 53.
42 and 53, both for day after tomorrow. And together, huh?
Item 43, my lords, I appear for the applicant, my lords.
My lord.
It's a section 11 petition, my lords, against the military engineer services.
Yes.
Page 12.
Yes. After vacation, no, day after tomorrow.
My lord, he said he will be here. There is nothing in this application. If my lord just hears it out, they have given a panel of 21. Arbitrator, we are agreeable to 5. It's a very simple thing, my lord. In their opposition, they have given.
Here is a pairing matter. What can we do?
Okay, my lord, my lord.
She had instruction, then I can pass an order. She doesn't even have instruction.
Tomorrow?
After vacation. Keep it on 10th of June.
Now, may I request any time before, my lords, in June, there is some.
The other side lawyer is unwell, sir.
I appreciate, but anytime, my lord, before the court closing, that's
Before the court closes, it won't happen.
very.
None for the petition. In the interest of justice, adverse orders are deferred. List on 24 June. Yes.
May it please, your lordship, my lord, this item 45 is my section 11, my lord, and item 55 is my learned friend section 9. But the matter is going to be settled, my lord. I'm instructed.
I think we can sort it out.
My lord, may I only
Interim order be extended.
my lord,
My prayer.
may I pray that if it is kept in the second week, my lord, fortnight after the reopening, by then, my lord, I'm instructed that the signing will be done.
Let the interim order be continued till end of June.
Yes.
When is the interim order expiring?
It's expiring roughly will 16th of June. I cannot pick.
That is item number?
Item number 55, 16th or 17th. That is my calculation. It may be one day.
Senior, just senior.
20th January, my lord, it was the interim order was granted.
28th January for a period of
8 weeks.
8 weeks from 23rd February. my lord.
23rd February. Right? 8 weeks for April.
So when will it expire?
Yes.
Yes, I stand correct. 24th of April, it was extended.
I hope it
24th of April extended for
will at 8 weeks, it takes us, according to my calculation, 17th of June.
17th of
My
June.
junior said it's 19th of June. I leave it to your lordship, my lord, keeps it, my lord, till the end of June. I can, my lord.
Around 24th, 20th of June, my lord.
Say
So it comes to around 20th of June.
If you want this matter to be
15th of June, if the matter is, my lord,
15th of June.
taken up, will come back. my lord. Very deeply
Just
obliged.
extend it till 15th.
All right, learned counsel, इसमें लिखो item 45. Learned counsel for the petitioner parties state that they are exploring the possibility of an amicable settlement. They pray for an adjournment. Let this matter be adjourned to 15th of June. Along with
Because 20th, my lord, if the calculation keeps it.
along with APCOM 49 of 2026.
Both 45. 30 was kept it on 50.
Very deeply obliged. my lord.
वही ना तो I तो पहुंच What is it? I'm for the petition.
Yes, ma'am.
My lord, the affidavit of service, my lord.
Yes.
My lord, the respondent number 1 has received, she is appearing. Respondent number 2 and 4, my lord, has refused the section 11 application, my lord. And the respondent number 3 has the sealed envelope has not yet returned, but the track report shows that insufficient address. But the same address where section 21 notice was delivered to him,
Whatever it is, you have to deliver once again.
my lord.
Service has to be complete.
My lord, service with regard to section 20, in respect of respondent number 3 only.
Yes, whatever it is.
Respondent number 2 and 4 has refused
That will be deemed service.
deemed service.
But
And
we
if
have
my lord,
learned counsel for the petitioner states that seeks and is granted 2 weeks time to effect service on the respondents. Effect service on respondent number 3, right?
respondent number 3.
Respondent number 3, full stop. Miss So and so appears for respondent number 1, full stop. He further states that the respondent number 2 and 4 have refused service. Refusal of service is good service, full stop. Let fresh service be effected upon respondent number 3 within a period of 2 weeks. Affidavit of service to
My
be
lord,
filed
can
on the
it be
next
with,
date.
with regard to paper publication, the service should be
List after July, 6th of July.
fixed.
6th July.
For the respondent.
Who's for the petitioner?
The file. The paying for not to demand redemption matter. My document is that I don't have the
Not today.
paper.
But I am happy. My application, Malan, is the affidavit of my land friend is a caveator for on behalf of all the respondents. He receives service.
So my friend, my lord, to file affidavit, because my lord,
I
my lord, petitioner, my lord, was not a party to the arbitration. Her deceased husband was a party.
My husband is the
His
partner.
husband was the partner.
He died in 2025.
Partnership dispute, my lord. Possibly allow me to file a
But whatever may be the dispute may arise, maybe before the learned arbitrator.
So he not reasonable, my lord.
Take down. The petitioner has preferred the present petition under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute between the parties arising out of a partnership deed dated 21st March 2022. Learned counsel for the petitioner states that as per clause 25 of the said partnership deed, the petitioner number is a wife and petitioner number 2 is the son, my lord. Petitioner,
You are not a party, my lord, to the arbitration.
okay. Matter can be referred to arbitration. Learned counsel for the respondent objects to the maintainability of the present petition. He states that the petitioner is not a signatory to the partnership deed dated 21st March 2022. He states that the present petition is not maintainable. He seeks and is granted 3 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 4 weeks. Yes.
Lordship, this is my section 9 application. The visit has been scheduled next week. The receiver will visit the site and she'll prepare a report. Kindly keeps it up to 4 weeks.
Learned counsel for the petitioner states that the visit of the receiver has been fixed after.
4 weeks, Lordship.
When is the visit of the receiver?
Next week.
Has been fixed for next week. She prays for an adjournment. Let this matter be adjourned for 4 weeks. What happened to the appointment of the arbitrator? Section 11.
My lord, this is a formal application for extension of interim order which expired on the day of counting of the election results. My lord's order is at page 21. The matter was fixed on 29th April at page 23, and the interim order was for a period of 8 weeks, which takes us to 5th of May 2026. My lord, election second phase was held on 29th, which was declared as a holiday by this honorable court. So the matter was not listed on that date. Then first was a holiday because of Buddha Purnima. Second and third was Saturday and Sunday. On 4th, my lord, the election results counting was there. On 5th, we had mentioned, my lord had directed that we should make a formal application. The interim order expired on 5th, my lord. So we are humbly praying for extension of the interim order, which because of the turn of events, when my lord had fixed the matter and had extended the election, neither the second phase nor the counting was declared, my lord.
Lord, may I make one submission, my lord?
And I submit that this is not a formal application because my submission is at this juncture. My Lord Miller does not have jurisdiction to pass any order in this regard. Why do I say so? This is an award, passed under, the Micro, Medium and Small Enterprises Development Act, which my Lord's Leave I refer to as the MSME Act. In terms of Section 19, my Lord is well aware that 75% of the awarded amount has to be deposited. As of now, the award was for a principal amount along with interest. I don't think this will be disputed. This entire 75% has not been deposited.
My
May I
lord,
hand up one
I have
judgment?
deposited this amount, my lord, in August 2025. Thereafter, I was granted an interim order in their presence. That interim order has been extended 3 times, my lord. No, never this objection was. My lord, the first interim order.
My lord, is dated 25th 6, 2025. This is when 75% was ordered to
my
be.
lord,
Yeah. I apologize. I apologize.
Place my case. Page 7. Order dated 25th June 25 is the first order whereby we were directed to pay 75% at page 13. Top paragraph. Thus, 3 lines from that. Thus, at this stage, this court is of prima facie view that the direction to deposit 75% of the awarded sum can be passed in favor. And then kindly consider the last paragraph. 75% of the awarded sum calculated up to the date of the filing of the application shall be deposited. And in this, kindly see the last line. In view of the objection raised, the award debtor may pray for adjournment before the learned executing court. This was the interim order. Thereafter, my lord, on 15th of September 25, the interim order was continued. That's not in the application. Page 19. Order dated 15 September 2025. At page 20, last line, the interim order of stay of execution shall continue up to 30th November 25. My lord will kindly find this order is passed in the presence of the other side, just as the first order was passed in the presence of the other side. Thereafter, the interim order was extended on 17th November 25. I believe that order is, it's not on record. Where are you showing it from? My lord, thereafter it has been extended twice on 17th November and 30th January 26. On both days, the other side was represented. The last extension, which is extension.
15 December. Just for completeness.
Order should be done.
My lord, the last extension is at page 21. My lord, may I place all the orders in that, all the extensions. The initial order was 25th June 2025, which was extended on 23rd July 25. Thereafter, we deposited the amount on 8th August 2025, which is recorded in the order dated 20th August 25.
Insufficient. The amount which has been deposited by you is less.
My lord.
That's not
My lord,
75%.
my lord, on
How can this be extended?
my lord, on 8th August, my lord, on 8th August 2025, we deposited the amount. On 20th August 2025, the letter by which we had deposited, we had given a copy to my learned friend. And then on that basis, on 20th August 2025, the interim order was extended. No point was ever taken by them that the calculation is incorrect, my lord.
That is supposed to be done by you.
My lord, I had done, my lord, the act says the
Act
amount.
doesn't say that they have to do the calculation. 75%.
My lord, what?
You have to deposit according to your calculation.
My lord, the act.
You have not deposited the amount. There can't be any stay on it.
My lord, the act says I have to secure 75% of the awarded amount.
Till the with interest.
Yes, my lord.
Till
So,
the date of the filing.
my lord, the awarded amount was 1 crore 50 2
have
lakhs.
deposited 12273333150.
Yes, my lord. That
You should
includes,
have deposited 15290,584.
my lord, I have to deposit 75% of the awarded sum. I deposited 75% of the principal plus 75% of interest from the date of the award till the date of filing of my Section 34 application, my
You
lord.
can't do it according to your own terms. You have to do it in the.
My lord, since they never took an objection, we believe that the registrar also accepted that calculation, my lord. First time now they are taking that objection, my lord. They have to give a
You
statement.
can allow them to file an application.
My lord,
Reply to
We
this
have already
application.
filed an application, my lord. It was meant to come on board.
Reply to the application then. We'll see that. We'll consider
my
the
lord, since this objection has been taken for the first time today, since the deposit made in 2020, August 2025, my lord, I was humbly praying that my lord will extend the interim order subject to whatever amount is finally agreed to by between the parties as to
It
the
can't
amount
be
due.
between the parties.
May
You
I-
have to do your own calculation and deposit the amount.
May I place one, my lord, my lord's own order, my lord.
You have your calculation. My lord, we had given.
Sorry.
This is what calculation?
My lord, may I place it, my lord? My lord, if my lord would be pleased to come to page 3 of this order, my lord, I'll not place the entire thing. Page 3, my lord, the third paragraph. The issue raised is no longer res integra. The coordinate bench of this court in such and such has comprehensively examined the interplay between sections 19 and 24 of the MSME Act on one hand and the scheme of sections 34 and 36 of the Arbitration and Conciliation Act on the other. The learned single bench of this court in the said matter held that the requirement of depositing 75% of the award is a mandatory condition precedent for entertaining an application under Section 34, challenging an award rendered under the MSMED Act. It further held, this is important, that such requirement is jurisdictional and in the absence of compliance, the Section 34 application itself is rendered non-maintainable. Consequently, the court held that unless statutory precondition is fulfilled, an application cannot bypass Section 19 by invoking Section 36 for an order of stay, since the right to seek stay flows only from a duly instituted and maintainable Section 34 petition. My lord, I will just, my lord, while the entire thing is important for today, my lord, I'll just, my lord, rely on one more sentence. My lord, may come to, my lord, page 4, my lord, the last sentence at page 4. The requirement of deposit cannot be relaxed or dispensed with even on alleged procedural grounds unless the legislature itself creates such an exception, which it has not. Here, my lord, there's no question of substantial compliance of 75%. Even 74% is, my lord, not enough. And unless that 75% dot is submitted, my lord, with due respect, my lord does not have any jurisdiction because the 34 itself is non-maintainable.
My lord, may I make one submission? The award was for 1 crore 52 lakhs principal amount. My lord has the award. Page 39 of the stay application.
GA1.
The award starts at page 27. At page 34. My lord has got the award. At the bottom, the order, paragraph number 2 of the order, the respondent is directed to pay an outstanding amount of 1 crore 52 lakhs 90,584 along with interest on each and every due amount payable as per Section 16 of the MSME Act. So what the MSME Council directed me to pay has quantified the principal amount, but the interest portion the Council has said you must pay as per Section 16. What we did, my lord, we have submitted 75% as per the mandate for getting my application entertained, 75% of the awarded amount, which is 75% of this 152 and 75% of interest from the date of the award till the date of filing of the application. That comes to, my lord, 1 crore 22 lakhs.
So we have deposited 75% of the principal amount plus 75% of interest from the date of the award till the date of the filing. We deposited this. On the basis of that, the interim order was passed and extended. Today, for the first time, they are saying that this amount is insufficient, my lord. Kindly give me an opportunity to consider it and come back. Kindly extend. Since this interim order has been in existence for a period of 8 months, my lord, that is, unless an objection is raised, my lord.
Objection is being raised by them today. I have to
My lord, they
consider
must
the
give.
objection.
They must give the calculations.
Then file a reply.
My
to
lord,
the
I have filed an application where the calculation is given.
kindly
I
give
can
us an
send up the
opportunity.
calculation separately.
Come back with the calculation in that
My
event.
lord, let it appear shortly. My lord, let it appear before the vacation. May I ask for one direction?
You make the payment,
My lord.
whatever the amount is, will.
My lord, since this point was never raised, my lord, that is why
It's being
raised, my lord. So
Jurisdiction.
we should, all that I was praying, that an opportunity to come back with the calculation which they are
Come
alleging.
back with the
Yes,
calculation.
my lord. Yes.
When do you want to come back? I'm not passing an order. Today I can't pass an order.
My lord. My lord, Friday, can you do it? My lord, no, later. My lord, can we come back on Friday? Is it possible? I'm not in, for personal reason, I'm not here till Thursday, my lord.
Come back after vacation then.
My lord. Grateful, my lord.
At the request of the learned counsel for the petitioner, let this matter be learned senior counsel for the petitioner. This matter be considered on 10th of June.
My lord will kindly consider, since that order was there, that in the meantime we'll be at liberty to pray for adjournment of the execution proceeding, because my lord is in season of the matter and there has been an interim order for such a long time, a limited.
Cannot receive.
Today I can't.
My lord.
I'm grateful, my lord. Deeply grateful.
I know I'm unnecessarily burdening your lordship, but item number 88, there was severe urgency. And the issue is completely covered by your lordship's own order of 19th of December. Identical arbitration clause. Any day, 3 minutes, I will, if I can satisfy your lordship.
Who's on the other side?
Ugro Capital. I will,
Just inform them, then mention.
very well.
maybe have indulgence, my lord. It's our mistake that we thought our 2 p.m. is appellate side. My lord, we did not mention the urgent determination of Justice my lord Krishna Rao. But my lord, we got informed that my lord has taken the mentioning of appellate side in the morning. So maybe we be permitted to mention now.
What is it?
My lord, urgency is, my lord, this is a tender matter. My lord, my nomenclature participation has been cancelled. My lord, on a ground, my lord, saying that they have tested my materials, but at all that was never done. My lord, it's a paperwork which was done. And my lord, we are still supplying, we are existing supplier. There is no complaint with regard to the material, which is now again be retendered.
What is the stage of the tender?
My lord, it has the bids have been opened. My lord, but work order has not yet been given.
Financial bids open.
Which financial bids are open.
We'll see it later. No urgency.
My lord, if the work order is being issued, my lord, then I will be in a difficulty, my lord.
Urgency.
My lord, they are extending my work.
No urgency.
My lord, financial bid open, financial bid open.
फाइल कर दो फाइल कर दो
there are unlimited content applications that should come up with link for an artist so that we can use the direction so that we find implementation of
Milord, this matter is, Milord, the petitioner was a candidate of a school service commission. He qualified. After qualification, Viva is started. But as my name is struck down from the voter list in SIR, I prefer an appeal. Not I was not called for. But there, for that reason, your lordship directed.
Regular bench. Regular bench.
Huh?
Regular bench.
Regular bench.
one of the grant of license of one of the petrol pump. One of the land was shown by the their chosen candidate was or has the land of Shali land where he desires to one of the fields go down. But challenge is that for the land authority appeal is pending. But one of the issue is before the district magistrate who is now going to one of the issue in favor of that person so that he can get the license. But unless the district magistrate is restrained till the one of the decision of this appeal before the authority of the land that whether a Shali land can be.
Sir, when was this done? What is the urgency today?
But urgency is this one of the it is before the district magistrate where I made
When did you make the representation, sir?
appeal filed in March 16th, but that appeal has not yet been decided.
All right, so no urgency. Right?
But
Sorry, nothing doing. You have waited.
But this
March,
is the.
you will wait for another 2 weeks. Yes.
But your lordship only I may beseech your lordship
Yes.
direct the one of the land authority to decide the issue.
I am doing nothing. Go before the regular bench.
Madam, covered by the order of the regular bench, this is a matter relating to SIR tribunal.
Yes.
The urgency is, my lord, on 25th, my visa is going to be, my lord, my visa is hearing. Now, visa is not being renewed only on the basis of the SIR. Now, my lord, I had made the representation. I have also handed over the copy of this order passed by the regular bench that you decide my issue. But if your lordship kindly hears this, because 25th, my lord, if my visa is not renewed, I cannot go to UK, my lord. That is the whole difficulty.
That is pending with the SIR.
SIR tribunal, my lord. Only a direction, but nothing else.
They will do whatever they have to do.
My lord, yes, my lord, they are, my lord, since 2000 March 2026, this is pending before the authority. I am only seeking a direction. But this, kindly since this order passed by this honorable court, only a similar order.
When is your visa expiring?
25th, my lord. I have applied, but they are saying.
Apply.
I have applied, my lord, April 26, my lord. And the authority has said, unless this appellate authority decides my issue, my visa will not be renewed. I have to report to UK, my lord, on 30th, my lord. Great friends.
The same order will be passed in my matter also. I will not be called.
Sorry?
The same order is to be passed in my SIR.
What is your
Otherwise, I
SIR,
will
sir?
not be-
Are you traveling somewhere?
No, I will not be called for viva, my lord. I was qualified in a.
Sir, this is somebody's passport. Liberty.
That I have.
Platforms.
Call the list. Judgment.
Side, commercial division for judgment item number 1.
Execution petition stands dismissed. अरे बहुत सारे हैं जल्दी जल्दी बताओ ना अरे हाँ call the numbers. What is the number? APCOM number 2. Give me the list.
APCOM number 9. Item number 2. APCOM number 907 of 2020.
Dismissed. APCOM 2. No, wait a minute.
Item number 2. Minor APCOM 907 of 2020.
All questions on the merit of the disputes are expressly left open to be decided by the learned sole arbitrator. In accordance with law, it is clarified that no observation made by this court in the present judgment shall be constituted an expression of opinion on the merit of the dispute between the parties. The arbitral proceeding shall be conducted in accordance with the provisions of the Act. With the aforesaid direction, the present petition stands allowed. All pending application, if any, stands disposed accordingly.
Great.
Arbitrator is appointed.
Great.
Number 3. ECCOM 197 of 2026.
Dismissed. Dismissed. Dismissed.
ECCOM 198 of 2026.
5.
5. ECCOM 199 of 2026.
Dismissed. 6.
6. ECCOM 200 2026.
Dismissed. 7.
7. ECCOM 201 2026. 8. ECCOM 203 2026. 9. ECCOM 219 of 2026.
Dismissed.
10. ECCOM 2 of 2026.
Dismissed.
11. ECCOM 249 of 2026.
Dismissed.
12. ECCOM 277 of 2026.
Dismissed.
And 13. ECCOM 292 of 2026.
I appear for the item number 13.
Item number 13. L&D Finance. Dismissed.
ECCOM 292.
After this.
Original side. Sorry, there was an original side matter at 2 p.m. that
After this.
that will be withdrawn.
You're withdrawing it. Which
Withdrawn. Lordship, item 1. Lordship have been kind enough to
Yeah.
give me leave on Friday.
Passport.
Passport one?
Yes.
All right.
I mentioned this on Friday. Lordship have given me leave. Now the issue has been solved, my lord.
All right. When
The
the direction
Grateful.
was magistrate for
Yes. Now the passport
Yes,
of
sir.
the given.
They have extended the passport.
learned counsel
Yes,
for the learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn.
Commercial item.
Grateful.
Deeply obliged, my lord.
Item number one.
Item number one, I'm for the petitioner, my lord. The petitioner wants to withdraw the matter because the grievance of the petitioner has been redressed by the respondent authorities, my lord. Petitioner has
Petition
given a written instruction.
seeks to withdraw the present petition. The same is take line down there now. Instructions to withdraw the present petition. Instruction to withdraw the petition given by the client is taken on me.
Item number two.
I appear for the petitioner, my lord, led by Mr. Shubhish Anna, learned senior advocate, my lord. It has come up at my instance, my lord, for extension of interim order that is expiring on 20th, that is day after tomorrow, my lord, as per the last order of 25th of March 2026.
Yes, sir. Yes.
But government not happy again. Okay.
So you have any objection? Who are you appearing for?
For the private respondent, my lord.
Take down.
I am not happy on behalf of the government.
That is
Or may I file my reply, my lord, to the affidavit filed by the private respondent, my lord?
reply filed by the private respondent.
By the petitioner, my lord, to the affidavit in opposition filed by the private
Reply filed by
respondent.
the petitioner to the
Copy
affidavit
letter,
in
copy
opposition of respondent number 16 is taken
Reply.
on record. This matter has come from is taken on mentioning from the board of Honorable Justice Krishna Rao. Learned counsel for the petitioner submits that the interim order granted earlier, which has been extended from time, is expiring on 20th 20th of May 2026. She prays for the extension of the same. That the interim order granted earlier be extended for a period of 6 weeks, whichever is earlier. 4 weeks, 4 weeks, list of the 5th week. 4 week के बाद दे दो. Give a date after 4 weeks.
Four weeks was 15. 4 weeks. 4 weeks adjourn extension. Madam extended for 4 weeks, madam.
4 weeks.
15 তারিখ হচ্ছে। No, 4 weeks. Malad has fixed the date.
15 June.
15 June. Grateful, madam.
I appear on behalf of the petitioner. I am led by Mr. Mukherjee and Mr. Basu. They are on.
I am led by Mr. Mukherjee, my lord. He is here.
Mr. Mukherjee.
Mr. Mukherjee will argue. I will not, my lord. I will assist him.
You argue kindly.
Yes, sir.
My lord, I have acquired a difficulty in speaking. I have requested Mr. Basu to the case on my behalf also. I can't speak, my lord, I have acquired a difficulty.
Yes, Mr. Basu, please.
Yes, my lord. This is the tender matter. I was supplying, my lord, to the ESI corporation. I was in the list in the panel. What happened, my lord? They subsequently by themselves they was not carrying on the tender matters. They was giving somebody else, and I was selected by them.
You are
In the
appearing for?
I am for the respondent 1, 2, 3. ESI Corp.
In the interagram, my lord, there was no renewal for any contractor. ESI corporation failed to renew anybody's credential, but I was continuing with that. But what happened, my lord? The present tender has been again issued by the ESI corporation. ESI corporation conditions, my lord, your lordship will get at page 23 at 35, which is relevant for our purpose. Can you turn over the page?
Page number?
Page 35. 35.
Yes.
Serial number 17.
Kindly come to serial number 17. The clause, it states that I have to be enlisted. Kindly come to the or portion, any government authority. That government authority, my lord, according to my submission of the tender documents, I was my lord, selected with the entrusted with the local corporation. Your lordship knows, my lord, the corporation has been constituted under 243Q of the Constitution of India, so it can be termed as a government authority. I produce this document for showing my credential vis-a-vis the tender condition. Now your lordship will kindly come to the bid summary, page 154, which is impugned before my lord.
Yes.
In 3 categories, I have been shown as no. But I
Serial
am asking this question to myself, what means no? No means my credential is bad, or I have not submitted any document. The documents submitted all are annexed to your lordship brief.
serial number 10, 11, and 17.
3 categories, my lord, I have been shown as no. The documents I have submitted all are annexed, my lord. I have uploaded. Without uploading, my lord, I cannot get enter into that. If you lordship recall, clause 17 of the tender document, it says that I have to be entitled to participate if I am government registered participant in the tender. That I have. So there cannot be any no so far my credential is concerned. On that ground, my lord, I have been rejected. My credential has been rejected.
And then,
but that rejection is subject matter of challenge before my lord. I was not allowed to participate. My tender financial bid has not been open.
and you made a representation.
Yes.
Yes, my lord.
A11.
Yes. Representation at page 157.
Yes, what is the stage?
But so far as my lord, my landed friend assisting me, my lord, he can apprise my lord. I am. What is the stage today? It has not been opened, I think. So.
Today, just at 12 o'clock, I received this brief. So I couldn't take instructions over the stage of the situation is concerned. But so far the case is concerned, lordship, the 3 heads under which the petitioner application has been rejected. These are the precondition for a tender document. Because ESI follows the general finance rules. As so far the general finance rules are concerned, these documents have to be complied with. Now, if you lordship kindly see, kindly come to page 35.
Pharmacy 150. 154. Oh, sorry, 142. This is the enlistment order.
My lord, kindly come to page 35.
Yes.
Here at clause 17, clause 4.
Yes.
Here it is specifically mentioned that the registration details as contractor, civil and engineering with CPW, CPWD, state PWD, MES, railways and BSNL. This is the criteria.
Or any other.
Or I'm coming. This is the criteria for submitting a registration document. Now kindly come to page 142. And 143, lordship. These are only the enlistment certificate, not the registration of the document for working with the civil PWD, PWD. Because here any other government body, as it implies the principle of adjunctant generis, lordship, of the same nature. Here they have only submitted the document as per 17 subsection subclause 3. certificate of incorporation, not the registration document as it is required, as well as they have not submitted the signed copy. Lordship, kindly come to page 155. Here at point number 10, page 155, signed copy of the tender document is required. They have uploaded only the digital signature signed copy. That was not the terms and conditions of the tender document, as well as clause number 17. They have also not filed the undertaking as per form 6. So these are the three heads and for which their tender document was not accepted. They were turned down. Because so far my respectful submission that the registration, so far the electrical and civil contractor is the ULUB only function as the administrative body. They are not the authority for granting registration. So far the civil and electrical engineer are concerned, my lord. They have failed to produce these documents, lord.
Beside their representation.
My lord.
Digital copy is not a signed copy.
My lord, the digital copy was not the, as per the tender document, digital signature was not required. It was required only the signed copy. It is one of the criteria, lordship. So for the under three head, under which the tender was not accepted, the digital signature was one of the.
So you will not accept digital signature.
So for the general finance rules, lordship, that was not allowed, my lord. Because as per the general finance rules of 2017, as per the mandate and the terms and conditions, we have to follow that guidelines, lord. These general finance rules is applicable for the year.
Say your tender, consider is.
My lord, kindly consider these are the ESI.
Say your tender.
My lord.
Tender stayed, decide his representation, after that open the bids.
My lord, these are the registration documents they have not supplied, my lord. Kindly consider.
I am considering it. Take down.
If the tender, my lord, is paid, my lord, these ESI hospitals, these are maintenance functions absolutely would be deprived because the employees of the ESI and the dependent family members are being treated at the ESI hospital.
All right,
if the tender is paid, lord.
I heard you.
Well, also subject to correction, I am still carrying on till 30th of June is my contract. It has been extended till 30th of June. So I am operating in the hospital. It is not the question that if the tender is not allowed, the patient will be at stake. That is not the case.
His license is not renewed, my lord.
The petitioner has preferred the present petition, being aggrieved by the inaction, being aggrieved by the action of the respondent authorities in rejecting the technical bid by the petitioner in connection with the tender floated page 23. Tender floated by respondent number 2 for the work titled Annual Repair, Maintenance and Operation, A bracket में डालना ARMO capital bracket close, electric work of the ESIC hospital, Uluberia and staff quarter. Full stop. For the year 2026-2027. Purportedly on the ground of non-submission of documents. Full stop. Learned senior counsel appearing for the petitioner submits that the petitioner is a reputed government contractor having several decades of experience in the field of civil, electrical and allied maintenance work and has been associated with the establishment with the employees. You have been working with them, right? You have been doing their work.
Yes, I am.
With the ESIC in the state of West Bengal for a considerable period of time. Full stop. It is contended that the petitioner had previously been enlisted as an approved contractor under the respondent corporation and has executed works of similar nature at the very same establishment, namely ESIC Hospital, Uluberia. Full stop. It is further submitted by learned counsel for the petitioner that the respondent routed such works through public sector undertaking, instead of directly issuing tender, as a consequence whereof the enlistment of the petitioner under the respondent corporation had elapsed. Full stop. According to the petitioner, he is presently executing works under the ESIC at Uluberi. This is ESIS, right?
ESIC.
ESIC.
Employees State Insurance Corporation, ESIC.
ESIC, Uluberia. The records reveal that respondent number 2, acting on behalf of respondent number 1, issued the notice inviting tender sometime in February 2026 for maintenance AMRO of the ESIC Hospital and Staff Quarter Uluberia for the year 2026-2027. Full stop. Pursuant to the issuance of the said NIT, the petitioner submitted its bid within the stipulated time. Full stop. A pre-bid meeting was held by the respondent on 26/2/2026, in which the petitioner duly participated. During the course of the said meeting, the respondent corporation rejected the technical bid of the petitioner on the ground that the petitioner, 1, that the signed copy of the tender document required to be uploaded was not provided. Number 2, registration detail as civil contractor with CPWDs, state PWDs, MES, railway / BSNL civil wing or any other government body was not provided, and that the undertaking bracket form C was not given by the petitioner. Learned counsel for the respondent states that the petitioner's bid was duly evaluated during the pre-bid meeting, and since the petitioner had failed to provide the above said documents in terms of section clause 17(4) of
Roman
the
4.
NIT, the petitioner was not qualified, and thus his technical bid has been rejected. What else?
So far as the discrepancy and adjustment error are concerned, there is a provision in the tender document itself that if there are varying and conflicting provision made in any one of the document forming part of the contract, the accepting authority shall be deciding authority with regard to the intention of the document.
This is one ground on which clause 17 violation, non-fulfillment of the condition of clause 17(4). What else?
3 document, may I just indicate?
Just a minute.
First of all, the clause 4 is 17.
Clause 4.
Second is the signed document, signed signature was not there.
He further states that the signed copy of the tender document required to be uploaded
And
was digitally signed and was not signed by the petitioner.
And another is undertaking.
The undertaking given by the petitioner in Form C was not in accordance with the tender condition.
Lordship, that I have disclosed at page 71, that have submitted.
As for the tender document under heading discrepancy and adjustment of error.
Yes.
In the tender document itself, there the discrepancy and adjustment of error, there is a provisions which provide that the authority shall be the deciding authority with regard to the intentions of the document. So for the registration of
which clause is that?
Here in the another matter, next matter, that page is there. They have in this matter they have not annexed that page, Lordship. It is in item number 4 at page number 64.
Item number 4 then. You have not annexed the entire tender document?
No, sir, I have the document which I have submitted in terms of the tender, I have entirely uploaded that.
Can you not put the entire tender document?
Lordship, some of the pages were eligible. Lordship, in the next matter, the entire tender condition I have.
Not entertain this petition. If the tender
No, Lordship, I have said that relevant portion I have annexed. That is my
portion, you have to put all the portions. How can you do this?
Lordship, kindly excuse me for that.
Oh,
Lordship, it was entirely my.
To be filed with entire details. You can't just file petitions like this.
Lordship, it is for my fault. Lordship.
If you pick and choose, then let them file their reply. Why should I hold anything then? File your reply. Nothing doing. File your reply. Learned counsel for the respondent seeks and is granted 4 weeks time to file their affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 10 weeks.
So kindly excuse me for this, entirely my fault, Lordship.
Please, sir, sorry. State so and so. This court is prima facie of the view that the respondent needs to file his affidavit in opposition. Seeks and is granted. 4 weeks time.
Lordship, in item number 4, Lordship, the entire document is before your Lordship.
Same order.
Same, Lordship, the same ground.
Same order.
Lordship, kindly have my
Same order, sir.
petition will be infructuous, Lordship.
It will be infructuous. You should come to the court with clean hands.
Lordship, in this second matter, Lordship, the entire document is before your Lordship.
Sorry. Come with clean hands to the court. There's one more matter listed tomorrow.
My lord.
2 o'clock.
I'll seek instruction.
Here. Next.
Item number 5.
Lordship, the affidavit service in item number 4.
Service to Delhi. But I'm in a very precarious situation here.
Yes.
Lord, I run a hut with a license, Lord, for the past 50, 60 years. There are 4 petitioners.
50, 60 years back, you were getting license.
Yes, Lord. I have a 52 years license. If your Lordship wants to see, Lord, I have it. Kindly have a look at it. It is Lordship. Kindly have a look at it, Lord. Well, I didn't believe, Lord, I got the client to get it. Now what happens is, Lord, this.
So the district board was constituted in.
At that point of time, yes, Lord, it was. But the act was not there.
File an affidavit that the board was there.
But at that point of
File
time.
an affidavit.
But I'm not even on that. I'm coming to what my problem today is. Ignores
these
it.
documents from anywhere, please, sir.
Willard ignores it. I don't even have to get into.
Know how these documents come.
It's very well. I don't even want to get into that. Now, my lord, I have a license. My license was granted to me till
50 years
26.
back, you think the board was there?
Animal husbandry, it wasn't under the animal husbandry. It was under the district board chairman.
District board chairman. You know, these are documents, how they get manufactured.
Milord, your lordship need not look into that. Very well. Need not look into it. But today's license is there, Milord. Have a look at that. That is annexed.
What is the urgency that?
The urgency is, Milord, my entire business has been stopped. Milord, they are renewing licenses for everybody.
When was your license cancelled?
Milord, March 2006. March 2006, and I applied just thereafter. Kindly have a look at it. Kindly turns to 33 once. This is below the trade license, and your lordship will find that it's running till 29.
Who's appearing on the other side?
We've served everybody.
Sorry, I'm not going to pass any order. Get
The legal remembrancer has accepted it. See, is my problem, my lord. This is a
thing doing. These are all the way he got this listed. I know.
well, it was mentioned before. Lord.
Yeah, I know. That's why I remember.
Kindly have a look at what my sees what my problem.
The respondents.
Please serve. They
Serve them again. Nobody's here.
my lord, then
If
serve.
the state doesn't come, we can't do it.
Now the problem is, my lord, if the panel is not.
I made a mistake. I shouldn't have got it listed. Learned counsel for the petitioner seeks and is granted. None appears for the respondent. Learned counsel for the petitioner seeks and is granted. 2 week time to serve upon the respondents. Let this matter be listed before the regular bench.
Now, may I serve on the authorities?
Whoever is the respondents, you serve them.
We serve upon the remembrancer. They've accepted.
Remembrancer, that will not do. You have to serve upon the.
Can you direct me that I'll serve? There is no GP office.
For the respondents, you have to serve them.
Well, the usual course of business is to serve upon the GP, but there is no government pleader now.
Not right now, so you have to serve upon the respondents who you have made party.
Very well, we'll do that. Below, your lordship gives me 2 days time.
Serve upon the respondents within a week. Serve upon the respondent left after vacation before the regular bench.
Lord, may it happen, Lord, before the vacation?
Not possible.
We'll do it, Lord, in 2 days.
Not possible. There's no urgency in this matter.
So if my business has completely come to a standstill.
Nothing is happening. There for 50 years, nothing is happening.
50 years I had a license. Now they're not renewing it.
Believe there's an immediate urgency. That's why I listed it. No urgency.
Good.
I was made to believe there's urgency. There's no urgency.
The problem is the festival is round the corner. The festival is round the corner, my lord, and if this point of time it doesn't happen, then there's a problem in the.
Which festival is around the corner?
The Eid.
Eid is also 27th or 28th.
Next Wednesday. Well, it's Wednesday week.
26th, I think, no?
20. It's within our vacation, so we didn't realize it, but it's within a week. So I was thinking if it can be done.
Regular bench.
Great.
Okay. Start from
Business side, commercial division, bill list item of 51.
Your lordship, appearing on behalf of the respondents, there was a direction upon the petitioner to file affidavit showing that the agreement was executed within the jurisdiction.
Lordship, I'm appearing on behalf of the petitioner. Lordship, I'm being led by Mr. Rituban Shorkar due to a personal difficulty in his family. He will not be able to appear today. I'm praying that this matter be taken up after the vacation, on the other side of the vacation, Lordship.
If it is not there,
Taken to adjournment.
if somebody is ill health, you're a lawyer. What are you? You're opposing it. Should I record it?
No.
Learned proxy counsel so appears and states that she is being led by Mr.
Rituban Shorkar, Lordship.
Rituban Sarkar, who is stated to be unwell. She plays an adjournment on his behalf. Let this matter be adjourned for a period of 3 weeks. 17th of June. 17 June.
Much obliged, Lordship.
My lords, in 52, my lords, they have moved an application for vacating, my lord, the interim order. No, before he begins, maybe we are in principle not disagreeable to what he is suggesting.
That's what you have said.
Yes, my lord. Yes, ma'am.
That's what you said.
Yes,
That
yes,
time you
yes.
mentioned.
Or in the affidavit, in the application, they have stated that they're willing to secure the amount because the post-award section 9, my lord. They have not challenged it. There is no stay. So let them secure the amount. Let them make a deposit in the court, my lord. The order can be vacated.
Your lordship, we had indicated to vociferate our bona fide. Today, your lordship, the two orders, they are nullities because this honorable court does not have jurisdiction. Lordship, so as of now, I am willing to secure to the learned jurisdictional. But with this court, your lordship, today, for the last 3 months, your lordship, my PAN account has been, your lordship, injuncted. I cannot operate my business. Your lordship, the second tertiary point that I've taken in my application is with the point of service, because this is the award not having been delivered to me, your lordship, even the letters and the records of the tribunal which my learned senior friend has disclosed, your lordship, it's not the service has not been effectuated on the complete address, which is why as of today, your lordship, we don't have a certified copy of the award, which is why we cannot prepare a section.
Then we'll file a reply to the application. The interim order will be continued. If he is willing to show bona fide and deposit the money without prejudice, let him deposit, my lord.
Lordship, today this honorable court does not.
No, I'll have to file a reply to
email
that.
also not,
No, I disagree. The award has been passed in Kolkata. The agreement says courts in Kolkata. I'll have to file a response to his application. No, it's a vacating application. Application for vacating interim order, my lord. I'll have to file a reply, my lord. In that case, I'll file a reply.
Oh, let me hear him.
That's why I'll indicate one. Yes. Lordship, will kindly just speak. Lordship, will kindly take up paragraph number 2 and 3 of my application, Lordship. 2, I have pleaded the two orders. Now, your lordship, you could recall in another matter, I had indicated that the distinction in Calcutta. The agency post road on one side, your lordship, it's the original side. On the other side, if we go cross the agency post road, then it does not fall within the original side jurisdiction of this court. Lordship can draw perimeter to, your lordship, probably the Lodhi Road juncture where you cross over and it's no longer, it's NDMC area, and on this side it's no longer NDMC area. Lordship, similar.
There is a
No, the award was passed, my lord, in the Bar Library Club in Calcutta High Court. So therefore, this is a section 9.
Make you a
No, I'm not challenging the jurisdictional fact. I'm seeking. I have an award. This is a post-award section 9.
is not where the award is passed, Mr.
No, but here it's slightly different, my lord, because I am seeking to secure an award. I'm not challenging.
All right.
So, my lord, the agreement says that Kolkata is the seat. Now, the second question is whether the original side of the High Court will have jurisdiction or it will be before the Alipur Court.
Correct.
Now, so far as that is concerned, my lord, one jurisdictional fact is that the award has been passed within the jurisdiction of the original side. Now, if I were to challenge, for example, under a section in a section 34, my lord, the
2-1 court is not according to where the award has been passed, Mr. Sataj.
then I have to file a response when it's appearing for the first time.
The order is per se not maintainable.
No, but on what basis is he saying that? I'm not in the application? It's not clear, my lord, because they are saying that. On what basis are they saying, my lord, that
territorial jurisdiction?
So what is the jurisdictional fact according to the petitioner?
According to them, this is not the 2-1 court.
No, on what basis, my lord? Because
on the basis
of the defendant's address.
Yes, this property doesn't really fall within the territorial jurisdiction of this court.
No, but
this goes to Alipur.
No,
that's what they are saying.
No, the property, my lord, the bank account may be even outside West Bengal.
Account can be anywhere. We are not.
There is no property involved here, my lord. It's only
property in the sense the agreement.
No, the agreement
parties.
My lord, so far as I will permit me to file a response, my lord, because it is appearing for the first time, my lord.
Why should I? This is regarding.
No, because I have to respond to this argument, my lord. I'll have to respond, my lord.
Somebody's bank account has, then you file it in 2 days. If the order is, see,
my lord,
I'm very clear on this.
My lord.
An illegal order can't subsist.
No, absolutely.
Whether passed by me or passed by anybody.
My lord, I will
satisfy. Then file it in 2 days and vacate the stay.
I will file it in 2 days, my lord. I'll have to satisfy that there is jurisdiction within. It is within.
Account is an important aspect of anybody's existence.
I appreciate, my lord.
If I have given a stay, I believe you. I've given a stay.
Yes, my lord.
If there's anything, don't argue for the sake
No,
of
no, no, my lord, I will respond to, I'll file an affidavit within 2
it
days.
carries a very bad reputation to
I
you.
appreciate, my lord. I completely appreciate, my lord. It's coming for the first time. Let me respond to it within 2 days, my lord. If it's not there, it's not there, my lord. Then my lord will vacate, my lord.
Learned counsel for the petitioner.
সেটাই তো হচ্ছে।
Is an application filed for
Adjournment
it's coming for the first time.
coming for the first time.
An application filed for seeking recall or setting aside of the orders dated 17th December 2025. Only one order.
There are 2 orders. Order dated 17th of December 2025 and January 28, 2020.
17th December 2025 and
January 28, 2026. The first order is at page number 10, your lordship, whereby your lordship, the RBI was directed. Subsequently, that was modified to on January 28th at page number 14, wherein my PAN card was injuncted.
And 28th January 2026. 28th January 2026. Learned counsel for the applicant states that this court is not the 2-1E court in terms of the agreement entered into by the parties. Full stop. The said fact is disputed by the learned counsel for the respondent. Letter he seeks and is granted 2 days time to file reply to the present application. Let this matter be listed on Friday. Friday.
Most good.
Can I just give one indulgence? Your lordship gives some precedence, and I say this with a sense of temerity. Friday, I understand.
All right, now I'll keep it in July.
No, no, I'll
sure.
tell your lordship why.
Now July.
No, I
No, no, nothing.
No,
No. Reply within a period of 2 weeks. Rejoinder to the reply within 1 week. Just after
I was just going to indicate why, because my
4 weeks.
PAN card is injuncted. I'm not able to
4
occupy.
weeks, sir.
It's only
I
to,
apologize.
only to the
That's the
extent of
reason
37 lakhs.
I was giving you Friday.
I understand, your lordship. I will.
Still, you want something more than
I don't. Like, the problem is Friday is inevitably there'll be a not to pass.
come after 4 weeks.
No, your lordship.
You will have more time. I'll
I'll
give you.
not-
I'll fix a time.
Your lordship will kindly not.
I'll
punish
give you
my
2
client
hours.
for
No.
my mistake, your lordship. I apologize. I sincerely apologize.
Young lawyer at the bar must know where the court is with you.
I apologize. Completely my fault. I can only seek for your lordship's sanity. I'm sorry.
Don't speak just because you have to speak. Court is already with you. You don't have to add more to it.
I seek to learn that. I apologize.
Most good.
Right.
May I please your lordship? My lord, this is a section 9 application wherein my lord Vide order dated 25th of February 2026 was pleased to protect the petitioner by granting an order of injunction and till the disposal of the arbitral proceeding. If my lord kindly takes up the order dated 25th February 2026.
Page.
My lord, this is my lord's order.
Page. Yes, sir. 26 February.
25th of February 2026, my lord. And my lord may kindly come to the last page, internal page number 4, the second paragraph, last line. And my lord, where my lord will find that the schedule B property until further order or till conclusion of the arbitral proceeding, whichever is earlier. Respondents were directed to file affidavit in opposition, and however, my lord, they have not filed, and the direction was there upon the petitioner to constitute the arbitral tribunal. My lord, pursuant to this order, we have already constituted the arbitral, and my lord was pleased to appoint an arbitrator. So, my lord, this application may be disposed of by continuing with the order, my lord, that is already subsisting. It is just
no.
Because
That
my
is
lord has already indicated that
that is for the
till
arbitral
my
tribunal
lord
to
has
decide.
already indicated that
No,
till
no,
arbitral
no.
proceeding. However, my lord, may I just say this thing? Allow me to file a section 17 application with the SEMCEL prayer before the arbitrator. Till that time, my lord kindly protects me. That much. Till that time, my lord kindly protects me. That till the time I file, the day I file, I have to move it. So that point of time, let the learned arbitrator decides on the issue. Till that time, kindly protects me.
I'll give you one more week for this. That's it. Learned counsel for the petitioner states that the arbitral tribunal has already been constituted in terms of section 11 of the Arbitration and Conciliation Act. Full stop. The present application has become infructuous. Full stop. Learned counsel for the petitioner shall move appropriate application in terms of section 17 of the said act. Full stop. Till then, the interim order granted, the interim order granted by this court dated 25th February 2026 is extended for 1 week to enable the learned counsel for the petitioner to file appropriate applications before the learned tribunal. Full stop. To go before the tribunal, I'm not going to explain.
Well, may I just beseech
I'm
one
not gonna
thing?
explain.
I'll
Go
not
before the
trouble.
tribunal.
I will.
I'll be influencing the tribunal if I
No,
pass.
no, 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 no. My lord, absolutely not. I'll not trouble my lord.
No, I'll be influencing
I'm
the tribunal.
completely bow down to my lord's order. What my lord has passed.
The tribunal will be at liberty to
Yes,
decide the said application, bereft of any of the observations made by this court. Full stop. And shall decide it in accordance with law.
My lord, just
None of
one
my
liberty.
observations should
No, no,
influence.
I'm not asking for anything. My lord has said 1 week. My
No,
lord,
I'm not
may-
giving you one.
My lord,
You
may
move
it
your
be
section 17. That will be
my lord,
influencing.
because there we have the vacation. The tribunal will not be there, my lord.
Sir, whatever it is, go before the tribunal. Now this
Yes, my lord,
proceedings
my
have
lord would kindly appreciate
nothing
we are
doing.
having our
Nothing doing.
vacation.
I'm not doing anything. Go before the tribunal.
My
Tribunal
lord,
has
the
been
learned
constituted.
arbitrator will not be there, my lord.
I am going to influence the
It's just
arbitrator.
2
I'm
more
not going
weeks.
to.
I'm just
I'm
asking
not
for-
passing an order.
Very well. I'm so grateful.
Seeks to withdraw it. Application is withdrawn. Dismissed as withdrawn.
Lordship, I'm appearing on behalf of
Yes.
the petitioner. Lordship, the arbitral tribunal has been constituted and the receiver's remuneration has been cleared. So we're withdrawing the matter, Lordship.
Learned counsel for the petitioner seeks to withdraw the present application. The same is dismissed as withdrawn.
Lordship, the same orders up until item number 60, Lordship.
56, 57, 58, 59, 60.
Yes, Lordship.
Same order.
Lordship, in item number 61, the receiver was to file her report.
You have got a copy?
Yes, Lordship, we have a copy.
What do you want to do?
Lordship, we'll also be withdrawing this matter.
Drawing. 61 also. Report of the receiver is taken on record. The matter is petitioner seeks to withdraw the present petition, dismissed as withdrawn.
Grateful, Lordship.
You have been paid?
Remuneration has been paid, Your Lordship. Grateful.
Lordship, from item 62 to 65, I'm praying for the same order as the previous matter.
Dismissed as withdrawn.
Yes.
We appear for the respondent in this matter. So that's
Your Lordship, this is my Section 9 petition.
perhaps the demurrer, my lord, there to satisfy whether there is an arbitration agreement subsisting between the parties or not.
Yes, Your Lordship. Your Lordship, please. No.
Agreement, where's the agreement?
Yes, Your Lordship. With the arbitration clause. 14F, page number.
Page number 20.
Your Lordship, come to page 27, Your Lordship.
Page 27.
Page 27. So this is the partnership deed, Your Lordship.
Yes. Rajaram Saraf versus and Manoj Kumar Goel.
Yes, Your Lordship. Both the partners are no more, Your Lordship. Yes, Your Lord. If Your Lordship comes to page 36 first, that how petitioner has come in the shoes of Rajaram Saraf, Your Lordship.
Page 30.
36. And Your Lordship comes to clause C. May I, Your Lordship, if I may read it?
Yes.
The death, liquidation, winding up, or disability for any reason of any kind of any of the partners shall not have the effect of dissolution of the firm. The remaining partners shall admit in his place one of the legal heirs representative of the deceased liquidated partner into partnership upon the same terms and conditions, and such admission shall be effective from the death, liquidation of the partner, and the amounts lying credit and debit in the capital of current account of deceased partner shall be transferred to such incoming partner. So, Your Lordship, the respondent who's first, Your Lordship, the second partner, not the Rajaram Saraf, the Manoj Goel, he expired and he nominated his son-in-law, nominated his wife. So he nominated on his place, his wife came in. What his wife did, his wife nominated his brother-in-law. His wife nominated his brother-in-law, Your Lordship. Now all the bills and everything which were issued by the brother-in-law, Your Lordship, we have not annexed it, Your Lordship, but we're carrying those bills. Then in 2024, Your Lordship, Rajaram Saraf died. I am the legal heir and executor of Rajaram Saraf. I'm his son as well and the legal heir as well. So that is how I have come in the shoes of Rajaram Saraf, Your Lordship. Now, Your Lordship, I'll just show you one more clause, Your Lordship. If Your Lordship can come to the arbitration clause, which is at page 37, Your Lordship. It's a very, very small dispute, Your Lordship, which has come. So 18A, Your Lordship, talks about arbitration. All disputes and differences between the parties hereto regarding the construction, interpretation, scope of effect of any of the terms and conditions herein contained or determination of any liability shall be referred to arbitration, and the same will be deemed to be a reference within the meaning of Arbitration and Conciliation Act 1996 or any other statutory modification or enactment thereto for the time being in force. Now, what has happened, Your Lordship, in brief, Your Lordship, the partnership asset, which was a land, Your Lordship, that has been sold. And we are anticipating that they have got some money as well from alienating that property, Your Lordship, and we are anticipating that some third party right will be created. So all we want is that a status quo needs to be maintained on that property, Your Lordship, otherwise nothing will remain. And Your Lordship, before I come back to the merits, Your Lordship, just one more thing. Before even coming into Section 9, Your Lordship, we wrote a letter to them asking that give us the account, what is the status, what is happening in the partnership firm. But they have not informed us anything, Your Lordship. That is why we are constrained to be here, Your Lordship. I'll just show you one letter, Your Lordship, which we have written. It is at page 50, Your Lordship.
How do you say that this property belongs to the partnership?
Yes, Your Lordship. Now, Your Lordship, there was an intention agreement, Your Lordship. I'll just show you that intention.
There is a document supporting that the property belongs to
the partnership firm. Your Lordship, if Your Lordship can come to page 24 once, Your Lordship.
As a death certificate.
No, I'm so sorry, Your Lordship. So the 25 is the intention agreement, Your Lordship. and typed copies at page 26.
Detention agreement doesn't give right to properties.
Your Lordship, I'll just show you. Your Lordship. Your Lordship, if Your Lordship comes to the last three portions, Your Lordship. May I read it, Your Lordship? Both parties will have 50-50% partnership share in the expenses incurred for this plant. Manoj Goyal, who is the respondent. Manoj Goyal will handle the production and maintenance of the plant with the advice of Shri Rajaram Saraf.
This is not a title document.
Yes, Your Lordship.
Not a title document.
It's not a title document, Your Lordship. This is the intention. But if Your
How
Lordship,
does the property belong to the partnership firm? Where's the document?
Your Lordship, it's a family company, Your Lordship. But I understand what Your Lordship is saying. But if Your Lordship, just if I may read it, just two
You
paragraphs.
are asking for injunction of a property saying it's a partnership firm where there's no document on record to show it's a partnership firm.
Your Lordship,
You want to withdraw or you want to?
No, Your Lordship, we do not
Then
want
I'll
to.
dismiss it.
No, Your Lordship, give me a day's time, Your Lordship. Please put it for tomorrow and I'll satisfy Your Lordship. If I'm not able to do it, I'll withdraw it, Your Lordship.
What satisfy? You don't have any document. Why should I keep it for tomorrow?
Your Lordship, all I'm saying is that it was a very informal agreement which
Madam, I can't. This is court of law.
I understand, Your Lordship, but there was a property involved, Your Lordship. Your Lordship,
Am I
the
denying this the
intention-
property? Show me the details.
Your Lordship, just give me a day's time and I'll be able to convince Your Lordship. Just give me a day's time. If I'm not able,
Not maintainable, not only on one ground.
Your Lordship,
Manoj Kumar Goyal's legal heirs. How do they become signatory here?
Your Lordship, I'll show you the document, Your Lordship, that they have been dealing with all the asset of the partnership, Your Lordship. This is the
Doesn't matter. Today you can't bind them to this agreement.
Your Lordship, but the clause, Your Lordship, is very clear, Your Lordship.
Clause for petitioner and respondent number 2, not number 1, 3, and 4.
If I may, Your Lordship, it is, Your
I
Lordship.
can dismiss it on multiple ground, madam.
Your Lordship,
Not one.
Your Lordship, Priya Goyal was nominated by the Manoj Goyal, Your Lordship. And she has nominated Manish Kumar Goyal, Your Lordship. These bills of 2021, Your Lordship, which shows that the work of the partnership firm was continuing, Your Lordship. We wrote letters to them, Your Lordship, saying that this partnership deed needs to be reconstituted, Your Lordship. But they did not pay heed to it, Your Lordship. The work of the partnership firm is still continuing, Your Lordship.
It's an admitted position that the property is in the name of Manoj Kumar Goyal. Right?
Yes, Your Lordship, I agree.
Then how do you say it belongs to the partnership firm?
Your Lordship,
Nothing on record, enough ground to dismiss it.
Your Lordship, it was a capital.
Madam, go wherever you have to prove yourself.
Your Lordship, just give me a day's time, Your Lordship. If Your Lordship can put it for not today, Your Lordship, I'll be able to satisfy Your Lordship.
Wednesday.
Obliged.
No, the maintainability point is still.
Draw it or dismiss it. Nothing is there.
Yes, Your Lordship. Not today.
The 7th, my lord, is my section 9 application. Lord, we've served them. My affidavit
You
of
are Mr.
service.
Nayak, right?
Yes, my lord. Service, my lord, appears to be complete, my lord. Matter, in fact, my lord, is coming up for the second occasion, my lord. For section 9, the only urgency that I seek to, my lord, impress upon your lordship is this revolves around a hypothecated asset. As per the agreement, upon the termination and failure of them to pay, my lord, the due EMIs, I am entitled to, my lord, take repossession of the asset. The urgency today, my lord, is that if today there's no injunction that is passed, they'll dispose of the asset, or at least that's what the apprehension is. I also have a prayer for receiver. But that possibly, my lord, order 40, there are certain principles, my lord, possibly it will be slightly unfair of me to press that prayer in the absence of the other side. But my lord, as far as the injunction is, my lord, concerned, considering that they've been served, my lord, I'll be able to press that. May I just place my case, my lord?
Yes.
Yes. Lordship will kindly, my lord, take up the original loan agreement. It starts at page number 26, my lord. This was between, my lord, the respondents and one Srei Finance. Eventually, my lord, Srei assigns the loan. I'll just indicate. Lordship, my lord, comes to page number 50. This is the asset. Page number 50 is a part of the loan agreement itself, my lord. If your lordship looks at, my lord, A1 asset details, this is, my lord, Cobelco asset. This is used, my lord, for construction uses. Lordship will come to, my lord, the arbitration clause, which is located at page number 44. At clause 23.
Page number?
44 of my section 9 application. The clause number 23, I'll just place any dispute or difference arising out of a concerning or touching upon the agreement at any time during its subsistence or thereafter, including disputes and differences relating to the interpretation of the agreement or any clause thereof, shall be referred to arbitration of a sole arbitrator to be appointed by the company. The arbitration shall be in accordance with the provisions of the 1996 Act and the rules framed thereunder as amended, replaced from time to time. The arbitration shall be conducted by a sole arbitrator to be appointed by the company in accordance with the provisions of the Act. If your lordship, my lord, looks at, my lord, the clause right below that, this is the governing law and dispute resolution. This is the jurisdiction clause. There are two clauses I'll place reliance on, my lord. First is 24.2. The borrower guarantor irrevocably submits and accepts unconditionally that the courts, tribunals, forums, as mentioned in the loan cum hypothecation schedule, shall have exclusive jurisdiction to adjudicate any disputes which may arise out of or in connection with the agreement and other related documents, and that accordingly any suit, action, or proceedings together referred to as proceedings arising out of or in connection with the agreement and any other related documents may be brought in such courts, and the borrower guarantor irrevocably submits to and accepts unconditionally the jurisdiction of those courts. This, my lord, read with page number 52. 52, my lord, the jurisdiction of courts, my lord, this clearly states, my lord, Kolkata. If your lordship looks at, my lord, B5. But subsequent to, my lord, this agreement being entered into, the loan cum hypothecation agreement, Srei, my lord, assigns its rights under the agreement, which was the creditor there, assigns its rights in my favor, which is Cobelco, the petitioner. My lord, the settlement agreement is there. The entirety of it, possibly, I don't have to place, my lord. Lordship will only take up, my lord, page 79 onwards. Only the relevant paragraphs, my lord, I'll place. 79 is where it starts.
79 is what?
79, my lord.
The assignment.
The settlement agreement. A settlement is the assignment agreement, brother. It's the nomenclature they use is a settlement agreement. But the essentially, my lord, the entire rights of Srei has been assigned in my favor. Your lordship, my lord, looks at page number 80, clause D. Hence, in consideration of Cobelco having agreed to provide the maintenance services to the debtors and towards full and final settlement of the outstanding equipment cost payable by Srei to Cobelco, Srei has agreed to instruct the debtors to make payment of the receivables under the aforesaid underlying agreements to Cobelco. And Srei has also agreed that on and from the effective date, all its right, title, and interest in the security shall also vest in Cobelco upon the terms and subject to the conditions hereinafter mentioned. Moreover, the receivable shall be set off against the outstanding equipment cost and the balance amount. Well, that in conjunction with my lord, page number 83, clause number, my lord, 2.2. This is under notice for payment. If your lordship looks at, my lord, 2.2. On and from the date of service of notice for payment on the debtors, Srei shall cease to have any right to receive the receivables, and Cobelco alone shall be entitled to the same instead of Srei. And additionally, shall have the right to appropriate all such payments from debtors towards the outstanding equipment cost. The collection right shall vest in Cobelco with respect to the future receivable amounts to the tune of rupees so and so. Now, this gets assigned in my favor. There is an arbitration clause which is contained in that agreement also. That also, the jurisdiction is Kolkata. This settlement agreement gets intimated to the present the respondents by a letter which is at page number 107. I'll just show two more documents. I'll end, 107, if your lordship looks at. This is, an intimation to the respondent, that is the debtor, that this agreement is now stood assigned in my favor. This is dated 17th of July 21. But immediately thereafter, we go and see that they have not paid their dues on time. pursuant whereof, my lord, we issue the letter at 109. That's the last letter I'll place, my lord. This is dated 21st of June 2023. My lord, this is issued to the respondents. By this, my lord, the entire agreement has stood terminated. That's the last paragraph at page number 110. I'll just place, as the said agreement has expired due to default committed in terms of the agreement, we on behalf of our client is hereby called upon you to hand over the said asset forthwith and make payment of the aforesaid dues within 7 days from the receipt of this letter to our client, failing which our instruction to our client is to take legal action. But one other clause, my lord, I'll just place reliance on, that's at page number 39. This is a part of the original, my lord, agreement, loan agreement. My lord, this is, my lord, the consequences of default and the enforcement. If your lordship, my lord, looks at 39, clause 14, my lord, subclause Roman small 3, my lord. Now, these are the consequences of non-payment or of default. But as a consequence, to take repossession of the equipment asset in the event that the borrower fails to make payment or rectify the default within a period of 7 days from the date of receipt of the notice, the company shall either by itself or through authorized representative agents, nominees be entitled to take repossession of the said equipment asset forthwith by entering into the premises of the borrower or from such other place where the said equipment and said equipment asset is parked without being liable or responsible to any person to trespass or otherwise, and thereafter initiate the process to sell and dispose of all or part of the equipment asset in a manner as set forth herein. But my section 9 is in aid of this. My lord, if I take your lordship to the prayers once, my lord, which is at page number 20 of the application. Page 20, my lord. A, I'm seeking for injunction restraining the respondent from dealing with or alienating the asset. B is essentially why the section 9 was filed. Slightly, my lord, circumspect. I don't know if your lordship will pass that order of receiver in the absence of the respondent. But 1A, my lord, I'm pressing today. Only, my lord, with the caveat that in case your lordship is pleased to pass A, lordship will clarify that I'll be entitled to renew prayer B on the next occasion. If your lordship is convinced as to pass A in my favor.
Take down.
No, this is, my lord, what the case stands.
Petitioner has preferred the petitioner, section 9 of the arbitration
It has completed.
1996, seeking
Wait a second.
an order restraining the respondent from dealing with, alienating, or disposing of the assets under the agreement being number 188148 dated 8/9/2020 and the settlement agreement dated 17/7/2021. Full stop. The case of the petitioner is that he is the successor interest of Shri Equipment Finance Limited. Bracket में S bracket close. Full stop. Shri Equipment Finance Limited in terms of the deed of settlement dated 17/7/2021, whereby the loan portfolio of Shri stood assigned loan portfolio of Shri regarding loan number वो जो ऊपर है ना 188148 dated 8/9/2020 stood assigned to the petitioner. The said assignment was duly intimated to the respondent by letter dated 17/7/2021 and was acknowledged.
Letter of termination.
You had informed him 17/7, right?
I'm sorry, my lord.
You had informed him of the loan transfer by letter
Yes.
17/7.
Lordship will find that at my lord.
Did he acknowledge it?
Yes. Well, the acknowledgement will be possibly, my lord, missed out. It's not annexed, but it's been served upon them, my lord.
What you have stated in your petition acknowledged by letter dated 4/5/2022. But that letter is not there. That's at the pleading.
2021.
এটা কোনটা গেছে বলো?
The letter intimation. এটা সার্ভিস কবে কমপ্লিট হয়েছে? এটা 17 July 21.
এটা ফাইন অনেক দিন হয়ে গেছে ওগুলো ইন্ডিয়ার
Well, the track report, my lord, I'm told, my lord, has not been possibly, my lord, it's not there with us anymore, but it's been intimated.
Don't say
But
acknowledgement.
irrespective, my lord, this letter,
Respondent by letter dated 17/7/2021. Full stop. It is submitted that
অনেক দিন হয়ে গেছে ওরা
she equipment finance.
my lord, only one other thing, my lord, in the letter dated 21st of June also, we have reiterated that the settlement has taken place.
No, no, I'm not saying that. The communication they have acknowledged, but you have not put the acknowledgement here. You have only stated in your petition. It's not part of it. Record.
But in the last letter, which is dated 21st of June 23, which is the termination letter,
Yes.
in that letter, if your lordship looks at, my lord, paragraph 3,
Yes.
this is at page number 109. If your lordship looks at paragraph 3, I've written, in the meantime, Shrey, being the debtor of our client, a deed of settlement assignment dated 17th of July 2021 was executed between Shrey and our client, that is Cobelco Construction Equipment India Private Limited, whereby SCFL agreed to instruct its debtors to make payment.
That's what I'm saying. The letter by which you have intimated the respondent, today the respondent are different. You have already written to them on 17/7/2021 stating that you have taken over the loan.
Yes.
But whether that fact has been acknowledged by them or not is something which I'm asking.
No, my lord, they have not issued any letter in acknowledgement. In fact, they have completely ignored me.
Order named by letter dated. Letter dated 17/7/2021. Full stop. It is submitted that Shree Equipment Finance Limited had advanced a loan of rupees, yeah, page 109 से हाँ 1105,000,000, huh? That which is rupees 1,10,50,000 to the respondent under the aforesaid agreement for acquisition of two Cobelco SK 220 XDLE10 excavators, repayable in 46 installments from September 2020 to June 2024. ये यहाँ सारा है हाँ इस paragraph, page 109. Should I mark it? Amount is here. Cobelco SK so and so. Okay. Yeah. 46 installment from September 2020 to June 2024. Despite the assignment and due acknowledgement thereof, the respondent committed default in payment of the said loan. Full stop. Consequently, the agreement was terminated on 21/6/2023 and the entire outstanding amount was recalled. Full stop. As on 28/2/2026, sum of rupees
original
279,156 when admitted is due by the respondent. Learned counsel for the petitioner submits that the agreement contains an arbitration clause and that the petitioner intends to invoke the same. It is further contended that there exists a reasonable apprehension that the respondent may alienate, transfer, or create third-party right in respect of the secured assets, thereby frustrating the arbitral proceedings. Upon consideration of the materials placed on record, this court is satisfied that the petitioner has a strong prima facie case. Full stop. The loan agreement, the deed of assignment, and deed of assignment clearly demonstrate a subsisting contractual relationship between the petitioner and the respondent. Full stop. It is evident that the petitioner, that the respondent had availed the loan facility for the said Cobelco XDLC excavators, full stop. This court is of the view that the balance of convenience lies in favor of the petitioner. The asset contains the primary security for the loan advanced, and any act of alienation, transfer, or creation of third-party rights therein would seriously prejudice the petitioner's ability to recover the outstanding dues. On the other hand, the grant of an ex parte interim order preserving the assets would not cause any irreparable loss to the respondent. It merely maintains the status quo pending adjudication of disputes through arbitration. Full stop. In view of the same, this court, to secure the end of justice and preserve the subject matter of arbitration, the respondent, its servants, agents, assignees are restrained for a period of 4 weeks from the date of passing of this order from alienating, encumbering, parting with possession, or creating any third party right in respect of the assets, namely that for Cobelco SK 220 excavators, forming part of the subject matter of loan agreement dated 1-88148, dated 8-9-20. The respondent is at liberty to file an affidavit in opposition within a period of 4 weeks. Reply, if any, within 2 weeks thereafter. List after 6 weeks. The observations made by this court are prima facie in nature and shall not have the effects on the merit of the disputes to be adjudicated by the arbitral tribunal. Full stop. List the matter after 6 weeks.
But along with the affidavit of service, my lord, I've also filed my notice of motion. Which will kindly, my lord, record that.
Notice of motion, affidavit of service is placed on record. Despite service, none appears for the respondent.
Need a card. No, 38, but the next matter is exactly the same. Only, my lord, in this case, I have to be
Loan
very
number
candid.
would be different and date would be different or the same.
The dates are more or less the same, my lord.
Assignment date will be the same.
Assignment date is the same. The date on which the intimation has happened is also the same. And, my lord, the termination notice date is also the same.
What is the difference? Only loan
Difference, my lord, not to do with the merits. So in this case, I'll have to be very candid, my lord. We served them. My lord, on 2 occasions we've served. Both occasions, my lord, the door is locked. That's the endorsement.
Serve them again.
This I leave it to your lordship, my lord.
Serve them again.
Door locked.
Learned counsel for the petitioner seeks and is
Akbar service
granted
complete
2 weeks time to effect service upon the respondent. List after.
Huh?
4 weeks.
Very good. No, my lord, I'm sorry, my lord. One of the affidavits of service, I'm extremely sorry, my lord. One of the affidavit of service, my lord, is delivered. One, my lord, says door locked. The other one, they can check. This is, my lord, 68, item number 68. So one, my lord, addressee is being served.
That will not. One addressee, I'm not going to pass an order, sir.
I'm sorry, my lord.
With one addressee, I'm not going to pass an order.
No, addressee, my lord, in one of the affidavits of service, it's been served.
See, one of them have been served. The other addressees also. You have to serve all of them.
No, I'm কতগুলো respondent আছে?
There are 3.
Yes.
Only one is served.
Yes. Then we'll serve, my lord, again. My lord, this was, my lord, the second time we served. But both times, my lord, it's come back with the same endorsement.
Serve them again. Find the address. Send your person. Do whatever you want to.
Or maybe, my lord, seek, if your lordship wants, we'll come up with an application. Otherwise, my lord, without an application, if your lordship so wants, my lord, we can make a paper publication also in the local newspaper there.
Serve them again.
Yes, sir. Well, 69 also, my lord, the same, but in this case, it's served. Everybody's been served. But this is along with, my lord, the notice of motion. Ek to judge sahib ke diye devo na. All the respondents served. It Ashok Yadav.
Sorry.
এখানে আলাদা কেন এগ্রিমেন্ট বিটুইন স্টে এন্ড রেসপন্ডেন্ট? Oh, প্রথম agreement. My lord, in this case,
Petition then?
the original loan agreement date will change, my lord.
Yes. And what else? Only date?
Only the date of the first agreement, the loan agreement with Sri. In the first case which I placed for item 67, it was
18848.
that for this one for the item 37 was 8th of September 2020. This is my lord 15th of September 2020.
इसमें सुनो.
बाकी सब same.
And the excavator?
Well, the asset is also the same. It's an excavator.
XDCL.
I'll just quickly tell my lord the
XDLC 10.
No, this is called, my lord. This is at page number 49, my lord. The asset description is given. It's slightly difficult to, my lord, enunciate this. Page number 49. This is KOB Kobelco SK220 for similar nature, possibly a different model number, my lord.
सुनो. दो चीजें चेंज हो गई. The date of the agreement is?
Well, the date of the original agreement 15th of September 2020.
15th of September 2020 loan agreement data. ठीक है. और पेज 49 यहाँ पे केबल को XK 220 XD-10 HYD EXC ये आएगा. तेज पे आएगा. Got it? ठीक है. To change loan agreement date, ठीक है, and the description of the Kobelco, ठीक है, वहाँ Kobelco XDLC है ना, वो चेंज होके हो जाएगा Kobelco SK220 XD, ठीक है. Got it? No confusion. नहीं 68 में affidavit 69. That's it. Perfect.
Rest, my lord, everything is standard form. Great, my lord.
Lord, I'm for the petitioner, my lord. The development agreement. My lord, I'm the developer. My lord, the development agreement has been terminated, and my lord, I'm asking for stay of the termination of the development agreement. My lord, my lord, if your lordship has prepared a list of dates. My lord, I have paid 2.5 crores. If your lordship turns over to the second page, my lord, I have paid 2.5 crores as security deposit. My lord, the initial understanding started from 2011. And then finally, if your lordship turns, my lord, to the third page, the second last entry, 16th October 2023, this is when the development agreement was registered. My lord, I'll show your lordship the clauses also. My lord, the developer's right is 68% of the realizations from the sale proceeds, and the owner gets 32% realization from sale proceeds. There is no allotment of land per se. My lord, there's a supplementary agreement also where there were issues with regard to, my lord, the land, my lord, the title to the land, which was, my lord, with the owner. There was some issue with regard to that because the title deed was not with the owner at that point of time. I will show, my lord, the deed. So, my lord, at the relevant, the supplementary agreement was executed where, my lord, the obligation was there for the owner to procure the title deed and give it to us, my lord. My lord, then, my lord, if your lordship sees, my lord, the 16th October letter, my lord, by this letter, my lord, again on the same day, the respondent addressed to the petitioner contemporaneous with the registered agreement, recording further assurances, undertakings, including commitments to take expeditious steps for securing disposal of GR case. Now, this case, my lord, was with regard to a stamp duty issue with regard to the original title deed, which is with the land, which was with the owner. Owner had, my lord, tried to get the document stamped, my lord. It was taken by the stamp department, and my lord, there was a case which was registered with regard to that. So the title deed was not with the owner at the point of time, and this case was pending. My lord, your lordship knows, my lord, till such time the original deed is there, my lord. My lord, sanctioned building plan cannot be obtained, my lord. Those were the necessary requirements. My lord, if your lordship thereafter takes, my lord, 17th October, there is also a registered power of attorney which was given in my favor. 1st October 2024, my lord, I obtained the fire safety permission also, my lord. My lord, then, my lord, starts, my lord, if your lordship takes the page 5, there were issues pertaining to, my lord, joint inspection and a boundary declaration. My lord, there were, my lord, when your lordship, my lord, when the boundary is required to be made, it has to be made as per the boundary declaration. When the boundary wall was being prepared by us, at that point of time, there were disputes from third parties, which resulted in delay and, my lord, correspondence being exchanged. This went on, my lord, as your lordship sees, my lord, till 27 March 2025. Subsequently, my lord, rather than them cooperating with us, the last entry at page 5, well, they declined to help us in any manner whatsoever with regard to the boundary declaration. Well, this goes on. Well, if your lordship takes, well, page 6, the last entry, 25th April 2025, there is also a case which is filed, well, before the Alipur Executive Magistrate, Alipur Court, my lord, under section 163, with regard to illegal encroachment in this property. All this was going on. That is why I could not start the construction work. Well, 13th June 2025 is finally when that case with regard to stamp duty, where the conveyance deed was with the department, that was finally quashed. And my lord, 14th of January, they terminate the agreement on the basis that, well, construction work has not started.
Terminated, what do you want now?
My lord, I want stay of the termination notice. My lord, if your lordship takes the clauses of the agreement, my lord.
What stay of it has?
My lord, they have also entered into a...
What can I...
My lord, stay, my lord, I'll show some judgments also where, my lord, they've also entered into an agreement with someone else now.
Then
My lord, I have paid 2.5 crores. I am in possession.
File an arbitration.
My lord,
I'll arbitrator appointed once. Then the equity is in their favor also.
My lord.
There's no question of if they have entered into an agreement, third party
Yes, my lord.
agreement. There's no question of staying the termination.
My lord, may I just show some judgments on this point?
And show whatever judgment you want to.
My lord, there's a,
Nothing is done.
my lord, this High Court's judgment on single judge.
Nothing is done, sir. You're wasting my time.
My lord, I will kindly just take that, my lord, for one moment. The lordship just considers. My lord, I am out of pocket by 2.5 crores. My lord,
You have your remedy available.
my lord,
This
but if the
section
development,
filed.
my lord, I am entitled
You
to
go
my
with
rights
the
under the
arbitrator.
development. My lord,
Go before the
termination is
arbitrator,
wrongful.
Whatever your rights are, you'll get it.
Well, if third party rights are created, I will be
Third-party
under.
rights are created, can't be stopped.
My lord,
They have
kindly let me
entered
just show
into
some
it,
judgments
They
on
have
this.
entered into it.
Well, let me just
Rightly, wrongly,
lordship
let
is.
your remedies be before the arbitrator.
Well, I will kindly just take in a section 9 similar facts, identical
facts.
facts, my lord.
I'm not convinced.
Well, your lordship will kindly consider, my lord. Just consider once, my lord. Well, if your lordship, well, it takes paragraph 3. Well, it's similar prayers as what I have sought here, my lord, including if your lordship sees last, the prayer C was operation of notice dated 9th July 2021, which was, my lord, the termination of the development agreement. If your lordship takes paragraph 5, the facts here, petitioner and the respondent number 1 entered into a development agreement dated 25th August 2009, followed by a general power of attorney, exactly like our case. Para 6, the petitioners paid 65 lakhs to the respondents pursuant to the development agreement. I have paid 2.5 crores. My lord, if your lordship takes paragraph 13, similar to our case, my lord, this is the argument of the respondent. My lord, paragraph 13, prayer D, subpara D. The respondent number 1 has entered into agreements with third parties,
Please read para
which is
9.
evidence. My lord,
Para 9.
para 9. The petitioners constructed some portion of the ground floor and the first floor of the building.
So,
these facts also confirmed by the receiver's report. Well, here I did not get an opportunity.
Doesn't matter.
I will show, my lord, from the facts.
Go before the arbitrator. He'll give you all
But,
of
my lord, if the development agreement is entered into by a third party, if your lordship sees, my lord, 13, subpara D, The respondent number 1 has entered into agreements with third parties. My lord, I'll show your lordship what all I have done. If your lordship goes back to the list of dates, my lord, if your lordship comes back to the list of date, my lord, page 2.
This is what played in the mind of the judge,
My lord,
that there's an investment.
my lord, here, my lord, I have not created, my lord, I did not get any opportunity to do any work, my lord.
So
My lord, the
there's a lot
construction
you have
work,
suffered today.
my lord, it
Seek
is,
recovery.
my lord, this is complete, the fault is completely of the owners.
Seek
If your lordship
recovery.
kindly takes, my lord,
Rights have
whatever
been
I could
created,
have
sir.
done.
We are the section 9.
Yes, my lord.
Some of us I have to be convinced
Yes, my
that
lord.
we have a right.
My lord will kindly go through the list of
Of
dates for 2
convenience,
minutes. I will show, my lord, what all I have
loss.
done. Prima facie, I will show, my lord, what all I have done. If your lordship takes, my lord. My lord, it's the second page, 18th March to 21st May 2014. I've paid 2.5 crores as security deposit. My lord, October 2014 is that case which is filed with regard to the title deed. This is against, my lord, the owner. I am not party to this. The title deed is with the owner. Title deed has been seized by the tax department, by the stamp department. 21st June 2017, the petitioner, that is I have obtained no objection certificate from urban land sealing departments. 26 November 2018, I have obtained no objection certificate from BSNL for height clearance for development of the subject property. This regulatory clearance was necessary precondition for building plan application. Then 17 December 2021, the petitioner facilitated the respondent executing a declaration deed confirming the boundary, extent, and demarcation of the land. This declaration is binding on the respondent, and my lord, I have obtained it. My lord, I have facilitated or obtaining it also. Then, my lord, all this while, because the title deed was not there and the development agreement was also not registered, all this starts from 2011. In 2023, my lord, is the development agreement which is registered. Kindly takes, my lord, 16th October 2023. Registered development agreement executed between the respondent and the petitioner, granting the petitioner exclusive development right. And 16th October 2023, this supplementary agreement is executed only for this purpose, that the title deeds are not there, my lord. Supplementary executed contemporaneously with the registered development agreement, regulating rights and obligations of the parties in respect of the respondent's obligation to procure and deposit the original deed of conveyance dated 4th September 2008. The deposit of this title deed with me was a precondition for me applying for sanction plan and starting the construction. That is what the clauses also show. I'll take your lordship through those. This has not been done even till date. So no question of me starting construction at all. Your lordship was saying prima facie case and equities. I have given 2.5 crores. I have made substantial expenditure and time already in obtaining various other permissions which are precursor to obtaining a sanction plan. The original title deed was required to be given to me. That is why supplementary agreement has also been executed. That has still not come. There was no question of construction starting or sanction plan being obtained. Then, my lord, your lordship will see 16th October 2023, letter issued by the respondent addressed to the petitioner, contemporaneous with the registered agreement, recording further assurances and undertakings, including commitment to take expeditious steps for securing disposal of the GR case. It is their case. They were, my lord, this GR case had been filed against them. It was going, they were proceeding with it. I had nothing to do with it at all. Then 17th October, the power of attorney authorizing me to deal with the statutory authorities applying for sanctions approvals. I could have done all those had I got the original title deed. Well, then your lordship will turn over again. 2nd December 2024, the emails, my lord, this I had read, my lord, where I showed that there are discrepancies in the boundary. Unless and until, my lord, the boundary wall is constructed, well, lord, I don't get right over the property. I'm not able to start any construction. I'm not even able to, my lord, make a plan and submit it with the department. So where have I gone wrong? I have not gone wrong anywhere, my lord. And my lord, your lordship will turn over to, my lord, the last entry, my lord, at page 5. I again write to them, rather than cooperating in the transparent joint survey, respondent responded with obstructive emails declining to participate in the joint measurement. They say, I will not do any joint measurement. Well, your lordship is saying a prima facie case has to be shown. Now let me show your lordship the clauses which will clearly show that there was no fault at my end at all, and construction applying for sanction plan or construction could not have commenced. Still, they have discharged their obligations. My lord will kindly take, my lord, the clauses. My lord will come straight to page 123. Page 123. my lord, clause 10, which is commencement of construction. With regard to time of commencement of the project of the said property, it has been agreed between the parties and the parties that the developer shall commence construction work of the project upon the owner making out clear marketable title to the said property, including compliance of the owner's obligation herein, which includes, my lord, deposit of the title deed. I will show that clause. To the said property, including compliance of the owner's obligations, and thereafter within 30 days of final sanction of the plan by Maheshtala municipality with a grace period of 30 days, upon obtaining all approvals necessary for development, including those under RERA or any other applicable laws, and there being no fetters or embargo on the developer in commencing development, whichever is later. The said commencement should commence maximum within 14 months from the date of the agreement, subject to the owner completing its obligations. Owner's obligations have not been completed at all, even till date. I will show those, my lord. I agree, my lord. This has to be finally decided by the arbitrator. But in the meantime, my lord, if third-party rights are created, my lord, then my rights will go. My lord?
It's already created.
My lord, that can be injuncted. That is what I'm showing, my lord. The judgment which I've shown, there, my lord, a development agreement had been created, yet, my lord, the notices were, well, I'll show the judgment. Your lordship will kindly see.
This judgment?
Yes, my lord. Yes, my lord. Kindly see.
Reason is because the petitioner in this case had already started the construction. There were two floors which he had already constructed, and that is what played in the mind of the court.
My lord, but in that case, my lord, your lordship will see the facts of the case. There were the obligations of the owner has to be discharged.
What do you want to read?
My lord, your lordship will take paragraph 13. Mr. Ghosh, learned advocate, appearing on behalf of the petitioner, submitted the following arguments. The para D, the respondent number 1 has entered into agreements with third parties, which is evidence of malafide intent and will subsequently frustrate their rights, leading to irreparable loss. Exactly my argument here, my lord. I'm pressing on that. And my lord, then your lordship will kindly come, my lord, to paragraph 23. Prima facie, I found that the contract was not one where the time was the essence of the contract. Exactly my case, my lord. 14-month period, my lord, that can be extended only upon subject to the obligations being discharged by the owner. Even if it was the determination that the arbitrator has to make. What is undisputed, though, is that there are certain amounts deducted with termination notices, which are clearly not contemplated in the agreement. Thereafter, attempts have been made to make commercial arrangement with third parties. Exactly the case here. With respect to the said premises, in my view, a prima facie case has been made out by the petitioners with respect to the validity of the arbitration clause and the injunctive reliefs. Furthermore, balance of convenience is in favor of the petitioner as development work has progressed, and termination of the same would lead to irreparable loss to the petitioners. In the light of the above, issue number 1 and 2 are decided.
Without even reading it, I was telling you this.
Yes, my lord.
As the development work has progressed.
My lord, here, my lord, I could not have progressed. My lord, there has to be, my lord, the obligations which are there on the respondent. Well, that has to be complied with. Your lordship will kindly take a few of the clauses in the development agreement. Yes, my lord. Will also take the termination clause, which is clause 35. Where is it terminable? Page 142, my lord. Page 142, clause 35. Neither of the parties hereto shall have any right to terminate this agreement, save as stated in clause 3.1 above pertaining to defect in title, that is, my lord, clause where I can terminate, and clause 11 above pertaining to power of attorney, all disputes. My lord, let me take your lordship to clause 11 and 3.1. My lord, clause 3.1 is at page 117. My lord, I'm not reading clause 3.1 in totality because that's my right to terminate. Because if there is a defect in title of the but just to show, my lord, in clause 3.1 at page 117, in case of any defect in title being found, which the owner fails to remove and or rectify within 90 days of receipt of written notice from the developer, under such circumstances, upon cancellation of this development agreement, the owner will refund. My lord, I have not cancelled. This is only my right. And my lord, clause 11, if your lordship comes, which is at page 124. The owner has simultaneously with execution of this agreement granted to the developer and or its nominees power of attorney inter alia for the purpose of smooth implementation of the development and construction of the project in terms hereof, and for such other issues as most fully contained therein. Since the powers granted is coupled with interest of the developer, the same shall not be revoked by the owner for any reason whatsoever, except in case of breach of clause 10 herein above. Clause 10 is, my lord, that commencement of contract, which I just read, my lord. So, my lord, first obligation is for discharge of the respondent's obligation to show clear and marketable title. And that is why, my lord, now let me take your lordship to the supplementary agreement which came on the same date. My lord, if your lordship takes the supplementary agreement, my lord, may I just show one more clause before I jump? No. My lord, page 118, my lord. Kindly takes page 118, clause 5. Immediately after execution hereof, the certified copies of the title documents of the said owner shall be provided by the owner to the developer. And then further, the owner shall deposit the original title documents in custody of Mr. So-and-so, Agarwala, advocate so-and-so, custodian, and Mr. Upadhyay, advocate, who shall be deemed to be a joint custodian to keep the original title documents of the said property safe, unobliterated, and free from all encumbrances, and shall produce the same before the developer and or its agents or any person of authority authorized by the developer, and also permit to be examined. This was a precondition, my lord, the deposit of the title deeds. That's why this clause was there. And this has, my lord, then come into the supplementary agreement also. My lord, supplementary agreement starts at page 196.
volume.
Oh, volume 2. 196.
Yes.
My lord, if your lordship comes straight to page 200, recital D. The aforesaid deed of conveyance, this is the original title deed, my lord, which is to be deposited with the custodians. The aforesaid deed of conveyance dated 4th September 2008 in respect of the first plot of land is subject matter of GR case number 2738 of 2014 pending before the Chief Metropolitan Magistrate at Calcutta, and the original thereof is lying seized in the custody of the government authority, Additional Registrar of Assurances 1, Kolkata. Upon the said original deed of conveyance dated 4th September 2008 being received by the owner, the same shall be deposited with the custodian, which shall then form part of the original title deeds. The owner represents that appropriate order has been passed by the learned Metropolitan Magistrate, Kolkata, 2nd August 2003 to release the original deed of conveyance dated 4th September 2008 on furnishing of a personal bond, and accordingly it is taking and shall continue to take necessary steps to obtain the said original deed of conveyance dated 4th September 2004. E. Since the development of the scheduled mentioned property would be dependent on the receipt of the original deed of conveyance dated 4th September 2008 for diverse reasons, the parties have agreed to enter into the supplementary agreement, which shall have an overriding effect. So, while the deposit of the original title deeds with the custodian, which can be viewed by the parties, was a precondition before applying for sanction or for construction. This is why, my lord, clause 10. Again, if I take your lordship back to clause 10, my lord, which is at page 123. Well, at the last two lines, upon the owner completing its obligations, and the emphasis is on making a clear and marketable title as mentioned before, herein above. And my lord, this happens, as I showed, my lord, from the list of dates, only, my lord, on 13th June 2025, when that GR case is quashed. Till 13th June 2025, my lord, the title deeds were not there. My lord, your lordship will take, my lord, page 241. That's the order which is there, my lord. 241, my lord. They appear before the High Court, 13th June, my lord. Finally, it starts at page 241, the judgment, and it is, my lord, at page 257. Your lordship will find, my lord, that the civil revision was allowed, and, my lord, the proceeding was quashed. That is when the title deeds came back, my lord. The entire issue, my lord, was that the title deeds has to come in the custodian's hand before which any step could be taken. This happens only, my lord, on 13th June 2025. In the meantime, there is other issues which were also being handled, my lord, where, my lord, as I said, the ULC clearance has been obtained. The clearance from the BSNL for high rise, that has been obtained. Fire safety has been obtained. Boundary declaration was made. Well, but the actual construction could not have taken place. It was their obligation to make a clear marketable title, get the title deed, get this proceeding quashed. And my lord, your lordship will now take the termination notice. Kindly takes, my lord, page 258, volume 2 only, page 258. Look, preceding 14 January are notices with regard to, my lord, the dispute with regard to the boundary and for encroachment, for which also proceedings are going on. My lord, kindly takes page 258. 14 January, this is the advocate's notice. It's been written to me. Redevelopment agreement of 16th October 2003. My client so-and-so. Upon being instructed by my aforementioned client, I write to you as under. Under the development agreement of 16th October, in respect of premises so-and-so, up to said agreement, your primary obligation was to commence the project by obtaining permissions, clearances, sanctions, NOCs, applicable permit, and commence execution of the project within 12 months. That's actually 14 months, not 12. 12 months from the date of execution of the agreement. Simultaneous with the execution of the agreement, you were given license to enter upon the land belonging to my client. Such license and permission was given to you exclusively for the purpose of commencing the development work on the said project to you in terms of the agreement, and pursuant to such authority, you have entered it upon the land, being satisfied as to the boundaries of the same. The agreement also records the time was the essence of the contract. It is not, my lord, as I had shown to your lordship. And the extension would be granted in situations beyond the control of the developer. That's not the case. Only when, my lord, the obligations have not been discharged by the owner, requiring and for the interest of the project. Since then, on pretext or the other, you have not commenced construction of the said land, nor have you evinced any desire to start such construction. On enquiry, my client has come to know that you have not even applied for sanction plan. How could I have applied for sanction plan, my lord, till the document comes in? Is it their case that it is their obligation to deposit the title deed with the custodians? I've shown that clause, my lord. That has still not been done. And then they make, my lord, other frivolous allegations. Your lordship will kindly take, my lord, page 259, the third paragraph. If your lordship takes the third paragraph, it has come to my client's knowledge from reliable sources that your parent company, BBT Elevated Road Private Limited, is in involved circumstances and is facing insolvency proceeding. The promoter director so-and-so is facing proceedings in insolvency. Well, nothing related to my facts. It's an altogether different company, not even this company. They make these frivolous allegations. My immediate response, my lord, your lordship will find page 261. I have taken every point I have dealt with. We'll take, my lord, paragraph 3. Allegations that the developer failed to commence project, lacked financial capacity, are baseless, defamatory, made without evidence. My lord, page 261, my lord. 261. Paragraph 3. If your lordship takes, the allegations that the developer failed to commence the project or lacked financial capacity are baseless, defamatory, made without evidence, and are denied. If your lordship takes paragraph 6, specific allegation with regard to that the promoter owner I've dealt with. Well, then paragraph 9, we'll kindly see. Your client has dishonestly suppressed material facts relating to delay caused by them in fulfilling their obligations under the said agreement. Project progress was materially affected by circumstances entirely attributable to your client and third-party proceedings, including but not related to. Mutation related to 4 Katha land was completed only on 26 September 2025. Title finalization of the land measuring 2 bighas occurred through registration of a sale certificate on 14 February 2023 pursuant to judicial proceedings before Debt Recovery Tribunal. Criminal litigation affecting title subsisted until quashed on 13th June. This is the order which I showed, my lord. Essential documents required for sanction and approvals remain pending despite correspondence dated so-and-so. Non-compliance with joint custody provision regarding original title deeds despite formal communication dated so-and-so. Third-party proceeding so-and-so. Then, my lord, paragraph 11. I've shown, my lord, what the material breach which is on their part. Prima facie, my lord, I'm showing, my lord, that the obligations which were to be discharged by the owner has not been discharged. September 2025 is, my lord, the property was still in involved circumstances. There were litigations pending. January 2026, within 3 months, they have terminated. In the meantime, there are other issues which are pending with regard to, my lord, the boundary, illegal encroachment, which is also continuing. And there are documents, the correspondence will show, my lord, that they are not helping us out. We have taken all steps. And well, not just that, my lord, your lordship will say equity is not in my favor. 2.5 crores they're sitting with from 2011 onwards. It's a substantial project. And my lord, your lordship, let me show your lordship the clauses by which with the entitlements come. My lord will kindly take page 108. The owner's share, 108. The owner's share, my lord, is the second last entry. Owner's share is 32% of realizations less deductibles as described therein. Developer share, my lord, page 106. 68% of the realizations. And my lord, your lordship, realization is defined, my lord, at page 110, the last entry. My lord, page 110, the last entry. Realizations shall mean the monetary proceeds, considerations, advances, and other amounts received from respective allottees for the transfer of the respective saleable areas or in any way related to project other than amounts received by way of extra charges, deposits from the allottees and amounts received by way of loans, finances. So from the sale proceeds. At the end of the entire project, construction cost is mine. That's also there, I'll show the clause if required. Everything I do, I have already started the work which is required. It is not like I could have done something which I have not done, for which, my lord, this third-party rights have been created. In the other matter which your lordship is seeing, my lord, their construction was going on, and at that point it was stalled. But there was no default per se, my lord, with regard to the owner's obligations at that point, pre-construction. Here, my lord, if I was able to do something and I did not do, then, my lord, absolutely correct, my lord, obligations would not have, my lord, rights would not have, equities would not have been in my favor. Here, my lord, I have paid, my lord, 2.5 crores in 2011. Since then, I'm sitting on this project. 2011 onwards. My lord will kindly see that clause also in the agreement once. 2.5 crores clause to that onwards. Will give me one moment, my lord. My lord, page 116. 116, page clause 2.2. The developer has on or before execution of this agreement, but I have the exact dates, I will show that also. The paid the owner a sum of rupees 2.5 crores. The receipt whereof the owner hereby doth admit and acknowledge as and by way of interest-free security deposit. I have paid this in 2011. I've been sitting on this project. I've been taking all necessary steps from that time onwards. September 2025 is when, my lord, the litigations have ended. Even then, there are disputes with regard to, my lord, the boundary declaration. Owners' obligations have been pending since 2011. 2023 is the registered agreement which I enter into. 2023 is again the supplementary agreement I enter into with regard to the GR case. Title deposit with the custodian was an essential term of the contract. That is why, my lord, if I just show that one clause again, my lord, I'm sorry, my lord, I'm taking your lordship to and fro, my lord. If your lordship, my lord, page 201, my lord, the supplementary agreement, the clause. Clause 5, my lord, the owner hereby assures and undertakes to the developer that the owner shall take expeditious and effective steps to obtain the original deed and deposit the same with the custodian named in the development agreement. On or before sanction of the building plan. Well, that has till date not happened. Where is the default on my part? Well, I'm also a businessman. I have put in 2.5 crores interest-free from 2011. I'll schedule type. Well, at page 194 is the schedule. From 2011, I've been paying money. They terminate the agreement. No mention of the interest-free deposit also. Well, they've been merrily enjoying this money from 2011 onwards. The original agreement in 2011, which was an unregistered agreement, that provided for 75 lakh rupees to be deposited. Subsequently, I made more deposits because I wanted to keep my interest in this property alive. My interest here is realizables. I'm not claiming an interest over the land per se, but the realizables when the construction is complete. Now, my lord, just a couple of more clauses and one more judgment, and that's it, my lord. My lord, possession also. If your lordship kindly takes page 100, page 99, my lord. Recital C, representations and warranties of the owner. Owner hereby represents to the developer, serial number 1, ownership. The owner is the full and absolute owner, lawful owner of the said property and has good and marketable title thereto. That is why all these clauses come in later on. And my lord, Roman 4, possession. The said property is in lawful, vacant, physical, khas possession of the owner. The owner has, on or before execution of the present, handed over vacant possession of the said property to the developer for the purposes stipulated in the agreement without any hindrance, impediment, restriction, prohibition, etc. However, on and from the effective date, the said property shall deemed to be in joint possession of the parties, and they shall continue to retain such joint possession of the said property, save and except in respect of the areas handed over, so and so. So, my lord, possession was also handed over to me. No dispute about it right now whatsoever. Title, my lord, whether they have title or not, that is something that has to be decided, my lord. That is why the supplementary agreement is there. And my lord, where have I not discharged any obligation? I have paid 2.5 crores. Ramakant Lal Choksi. My ultimate relief, my lord, in the arbitration proceeding is going to be for specific performance of this development agreement, so that I'm able to perform it, my lord. The lordship will kindly take, my lord, this recent judgment of Supreme Court. This was a case of an agreement for sale. But, my lord, let me show your lordship just the clause, the paragraph which is relevant, my lord. Your lordship takes paragraph 44 at internal page 26, my lord. Quite often in these types of litigations, it is sought to be argued that, my lord, internal page 26. Quite often in these types of litigations, it is sought to be argued. My lord, para 44, my lord. Your lordship takes para 44.
Okay, petition. That's a
My lord. Well, if I take it, your lordship, from para 43, my lord, in fact, we need not say anything as regards the subsequent transfer of the suit property at this stage, for the simple reason that if it has been transferred pending any proceeding, it is for the trial court to see whether the transaction is hit by lis pendens or not. This aspect shall be looked into by the trial court at the time when the suit is taken up for final adjudication as regards the rights of the parties. Quite often in these types of litigations, it is sought to be argued that an injunction restraining the defendant from transferring the suit property was absolutely unnecessary, as no post-suit transfer by the defendant can adversely affect the result of the suit because of the provisions of section 52 of the TP Act, whereunder all such transfers cannot but abide by the result of the suit. It is true that the doctrine of lis pendens as enunciated in section 52 of the TP Act takes care of all pendency-like transfers, but it may not always be good enough to take fullest care of the plaintiff's interests vis-a-vis such transfer. We may give one appropriate illustration of a suit for specific performance of a contract based on an agreement for sale. In a suit where the plaintiff prays for specific performance, and if the defendant is not restrained from selling the property to a third party, and accordingly a third party purchases the bona fide purchases the same bona fide for value without the notice of the pending litigation and spends a huge sum for improvement thereof or for construction thereon, the equity in his favor may intervene to persuade the court to decline in exercise of its discretion the equitable relief for specific performance of the to the plaintiff at the trial and to award damages only in favor of the plaintiff. It must be noted that in Rule 1 of Order 39 of the Code clearly provides for interim injunction restraining alienation or sale of the suit property, and if the doctrine of lis pendens as enacted in 52 of the TP Act was regarded to have provided all the panacea against pendency-like transfers, the legislature would not have provided Rule 1 for interim injunction restraining transfer of the suit property. Rule 1 of Order 39, in our view, clearly demonstrates that notwithstanding the rule of lis pendens under 52 of the TP Act, there can be occasion for grant of injunction restraining pendency-like transfers in a fit and proper case. Muktokeshi Don is a Calcutta High Court judgment, which is cited. Then, para 40. In the aforesaid context, we may refer to the one old decision of the Calcutta High Court, Pramotonath Roy versus Jagannath Kishore Lal Singh Deo, wherein it has been observed that court will in many cases interfere and preserve the property in status quo during pendency of a suit in which the rights to it are to be decided, and though the purchaser pendentiality would not gain title, the court will prevent by injunction embarrassment that would be caused to the original purchaser in the suit against the vendor. My lord, here also, my lord, all I'm seeking, my lord, the termination notices, that should not be given any effect to. My lord, as in the case, my lord, of, my lord, I agree, my lord, in that case, my lord, two floors had been constructed, but my lord, a development agreement had been executed with the third party, which evinces the malafide. And your lordship will see the facts here. The timeline also, my lord, till June 2025, that GR case was pending. September 2025, another case with regard to, my lord, land was finally sorted out. My lord, January 2026, they terminate on the pretext that I have delayed, despite the fact, my lord, that the title deeds have still not been handed over, which is a precondition under the contract, my lord. And my lord, February 2026, they entered into a new development agreement. They informed me about this development agreement by way of a reply to my reply to the termination notice on 9th March 2026, and I've immediately come before your lordship. Well, it's taken some time to come for the matter to be heard out. Well, if I am on the last occasion, my learned senior had had indicated that he's going to argue on jurisdiction, saying whether this is a suit for land and your lordship can't entertain. Should I address that right now or after my learned friend, if my learned friend takes that point? So I'll address it right away. My lord will kindly.
Mr. So-and-so. No further hearing. Day after. Day after.
Day after.
May I have your lordship type team, my lord, and the leave of my seniors, my lord. Extremely pressing urgency and at the risk of being admonished, my lord, there is a warrant of arrest that has been issued against, my lord, in an execution proceeding against a person. He is not a party to the execution proceeding. Only the award debtor is the company. Now, he had, my lord, resigned as the director of the company even prior to the agreement entered into, which contains the arbitration clause. Slightly irrelevant at this juncture. My lord, now the police is gone, my lord. He's in Mohali. My lord, the matter has been kept in June. He will come in, my lord, dispense with the warrant of arrest. The only difficulty, my lord, is that he's unable to come, my lord. He's met with an accident. He's unable to walk. There are rods in his leg. That's what's been told to me. He's not been represented in the execution proceeding either. No orders have ever been served upon him because the company was represented. Naturally, a former director was not represented. I was only beseeching your lordship to, my lord, kindly allow him to, my lord, appear virtually. He'll dispense. We'll also, my lord, comply with the order, file an affidavit of assent before this court within, my lord, the shortest possible time before Friday. If your lordship, my lord, keeps the matter tomorrow, he'll appear virtually, my lord. That's all that I'm seeking, my lord, today.
When was the order passed?
My lord, the order was passed on May, my lord, in the month of May, on 16th of May, my lord, possibly. 16th of May, my lord, the warrant of arrest was issued, post which the police goes in Mohali. He has never been a party to the execution proceeding. He has never, my lord, been...
Not be a party to the execution.
May not be, but naturally he's also not been served with the copy of the orders. So the order by which he was directed to file, my lord, the affidavit of assets, that was never served upon me. First time he finds out there were advocates who were appearing. Now the advocates have also stopped appearing. But I don't have...
Should have taken care of it.
He's not a director anymore.
So what? He should have taken care of it. If his
Well,
name is
well,
there, he should have taken
we'll
care of it.
there might have been well, some latches on everybody's part, well, including mine. Only saying, Lordship, kindly, with some amount of sympathy, allow him to appear virtually tomorrow. I only seek to have the warrant of arrest.
other side?
Kept. I'm sorry, my lord.
Who's on the other side?
Others will serve, my lord. We have the copy of the orders. I've just been instructed half an hour back.
First you serve them.
We'll serve. If your lordship directs it to appear, we'll serve today. It's before 5 o'clock, my lord, we'll serve. We'll make sure. Lordship keeps it any time tomorrow, my lord, and grants us the liberty to, my lord, appear virtually. I'll be here physically, my lord. Lordship appears, my lord, the person to appear virtually.
Thursday.
I'm sorry, my lord.
Thursday.
Thursday.
Actually, I'm praying for
We'll
leave
serve in
match.
the meanwhile.
Serve them first.
Just
Serve them. Come to
Lordship,
very well. Serve and come.
Lordship, I'm praying for leave in this matter, Lordship. This matter regarding to Slaughterhouse Act, Lordship. 13th May, Lordship, the notification has been issued.
Madam, please.
But I'm praying for leave only, Lordship. There is some urgency, Lordship.
No leave. Coming out of Justice Rao's bench.
Lordship.
Nothing doing.
Lordship, kindly, Lordship, there is some urgency, Lordship. We are the Ghosh family, Lordship. We are suffering lots of money, Lordship. Kindly.
No slaughterhouse.
Lordship, in the item numbers 56 to 65 today, I have inadvertently, I apologize, Lordship, I've made an error in my submissions. Instead of withdrawing the matters, Lordship, I'm praying if it could be recorded that the matters are disposed of as the arbitral proceedings have begun. So the section 9 would be infructuous. And Lordship, one more error.
Learned counsel for उसमें लिखवा दो, learned counsel for the petitioner seeks to withdraw the present petition since the arbitral tribunal has been constituted and the present application has become infructuous. Learned counsel for the petitioner will file appropriate applications before the learned tribunal in accordance with law.
Lordship, one additional error on my end was in item 61 where the receiver has filed a report. Lordship, I am praying for your leave for the asset to be sold in the tribunal, to receive a order for sale by the tribunal in this matter.
You have to move an appropriate application before the tribunal. You don't need my permission for that.
Lordship, if you could just record it in the order, please.
No, you have to move an application before the tribunal for that.
Much obliged.
The rest of it, I've changed it. Since arbitral tribunal has been constituted, you'll move appropriate application in accordance with section 17 application there only, in accordance with law, whatever.
Thank you.
Just a minute.